Megan. No. I promise you your comments on my market. Okay. Megan, can you hear me?
I can hear you now.
You can hear me?
Yeah.
Okay.
No, I don't know. He's here. He's got 3 or 4 cases. He's not going anywhere. He's not going. You know, big. I don't want him going over there. Oh, maybe right. So, no, they got not a rider, and the independent candidate running against the Republican nominee down the jail. He's not. Who is? He's incumbent too. Whatever happened to that boy? Oh, Charlene, she passed away. Did you? Yeah, she had lung cancer. You know, I read the lieutenant governor, she gave me a cold check for $500 as a contribution. She was. I was a bit sad till I moved back home. Changed over. Now I'm glad I changed. Nice. I told her she died. She's like, I said, you know, we got the Tyson tables at that time. I said, that's the best thing anybody ever did. Yeah, well, it is. It's the only job over. Well, and it's recession proof. You don't have to worry about a recession because everybody's going to keep eating chicken. Right. And I mean, it's just a lot of work. And also, people raising it. Yeah. She really appreciates it. I was. I didn't know she was so chill. That's her ex-husband, Brad. Yeah, thanks. He just did. You know how he got married and he had a step. We got him a pretty bad and state. And I don't know here and the moment. And he got the good deal. He got a better deal. Yeah. I'm going to do my best. Nothing. Being circuit board. Sort of, you know, I'm 78 years old. It's been 50. And just think about it. People just don't understand how stressful they are. How much they got. I've talked about it's like this. You have a system for every time you cry, it does. I cry a bit. You try to cases. Did you ever try to case before a judge? Going down. I've got it. For some 20 years in the States. If I can get my 27, I was 65. I'm going to see. I'm going to enjoy life.
But I'm 78 years old. Clay, he's still hanging on, and I don't know how old he is, but no joke. I was a freshman in high school, and he was my teacher.
It's not as easy.
I'm confident we'll tell the judge we're going.
Okay, that'll be fine. We'll tell them we're close. Our appointments.
So they can bring a lot of. They will be working. So what's the problem?
Well, and maybe another, well, they- but
I think that makes sense. Can you first go in and think we can do it for you?
I don't know.
I'd be happy to take one of them.
Well, did I get your thing?
Well, that's the ex-speaker of the Kentucky House of Representatives. He sits where he wants to.
Yeah.
I used to be something.
I never was anywhere. Oh, I'd be happy to. What I think we do. I don't know want to talk to the other. Do what I'm saying. Well, you can waive that anything. Yeah, I look at it. I really put it in writing.
They know those. Right. Very good one. It is so good. Well,
That's like when I tried to go with that very on my growing dope years ago, and just short. I shouldn't try to hit her, so I tried Joyce, and we blended on Michael, and I tried Michael, and we blended on Joyce, and we ended up putting both of them. Worked pretty good.
and they, so, and when it's money, it's easy enough to say. Right, when it's somebody, somebody.
Yeah. I agree. There's a lot of tough decisions. Yeah, just still just let's see what happens today and I need to do something else.
One time, oh, who I thought was great.
Duncan, I remember him. He's a nice old man when I knew him.
He tried, and what he tried, he wasn't mad at you. He had another one.
Mhm.
But anyway, he had this job
Thank you very much.
that he worked out. Oh, no. Well, they just-
Instruments, actually.
Can do that. Oh, I'm going. I'll have to- Apparently, you know, I got her. Oh, yeah. I just- We had a good boss. Norman Bonnet, this is Norman's last case. Morning Road. Duncan Miller, well, I like Terry Miller, I do too, yeah. But most of these stuff. Don't go anywhere. And then some bars not there.
Have my robe delivered over here. We got some Grangers here.
Thank you.
You want to come around, Granger? Good morning. Thank y'all for being here. You raise your right hand, please. You solemnly swear or affirm that you will conduct your duties as members of the grand jury of the Cumberland Circuit Court. And that you will faithfully execute those duties. You will keep all matters confidential. You protect and defend the Constitution of the Commonwealth of Kentucky. In the United States of America. You investigate anything fairly. It's brought before you. The clerk, when you lower your hands, the clerk will take them. We're gonna be a few minutes before we start. We got the case of the missing robe here. Has to be retrieved. My house. Y'all, anybody have anything, you have anything you need to talk about before we go on the record? Okay. Well, we just have 19 on the docket, so it won't take that long. Pardon?
I can get right over there. You got all of it.
You don't have the record on the.
I can. Is it on today? Wednesday, yesterday or Tuesday, late afternoon. He just started. I'm gonna get it. They said, advise the board to get this out. I'm gonna- Is there two of us?
Approach, Rob. Sure.
Okay, that's so two of them. Good, that's all I'm saying. They're on the- I just wanna put it there. Instead of a whole option.
Costello wanted these records, and based on our conversations, I thought it was well taken. And we'd ask for order to get these records and then reschedule the competency for the children after that.
No.
Y'all wanna move over to the left here. I can't hear you.
We just need to get an order in there so we can get, because we need medical records in this case, and then we can proceed.
Okay, do you have the order prepared?
I do.
Have you seen the order?
I have, Your Honor. I'm in agreement.
Okay, when does this need to be rescheduled? You just want to docket it?
Well, yeah, let's set it for the next motion day, and we can meet on the 14th. That's a negotiation day. We should have.
October the 14th for negotiation here at what time? 9 a.m. The next court day is October the 27th. Both of them are conditions to your bond, okay?
Thank you.
Michaela Beatty. Michaela Beatty.
Your Honor, we have companion cases
And
there.
Tyler Beatty. 21 CR 00128 is Michaela Bailey, and 21 CR 0027 is Tyler Beatty. You are Tyler Beatty. Okay, and you are Michaela Beatty.
Yes.
What's the Commonwealth have in this case?
No, we've met on this case.
Yeah, y'all gonna have to move to the left here. I'm having trouble.
We've met on this case. I think we're either close to resolving it, or the next motion day we'll ask for a trial date.
Okay. Do you want a negotiation date, or you, okay, y'all be here for negotiations on October 14th. Next court appearance is October the 27th. Okay, both of them are conditions of your bond, okay?
Is that 9 o'clock on the
9 o'clock
14th?
on both of them, yes, sir.
Thank you, Your Honor.
Okay, thank you. Amanda Branham. Commonwealth versus Amanda Branham. Commonwealth versus Amanda Branham, 22 CR 0047. Are you Amanda Branham?
Yes.
Born in 1984. Last four digits, social security number 9475. What do we have here?
We have an agreement for a pretrial diversion, Your Honor.
Ms. Branham, did you say your year of birth was 1984?
Yes.
Last four digits, social security number 9475.
Yes.
A motion has been tendered that says you wish to enter a plea today. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given?
Yes.
Are you the same person named in indictment 22 CR 0047?
Yes.
Is your judgment impaired today? Is your judgment impaired today? You know what's going on? Okay, have you had plenty of time to discuss this matter with your attorney? Are you satisfied with her advice?
Yes.
Have you had an opportunity to look at the evidence the Commonwealth has against you? You feel like you're fully informed about your case?
Yes.
You have certain rights under the Kentucky and United States Constitution. You do not have to enter a guilty plea today. I'm going to go over these rights, and at the end, I'm going to ask you if you understand them. You have a right not to testify against yourself. No one can make you say anything. Right to speed trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to a higher court. If you lose, you have the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. Understand that by entering a guilty plea today, you give up those rights. You understand that?
Yes.
I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I do not have to accept any recommendation of the Commonwealth. In the event that I do not accept the Commonwealth's recommendation to decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. Now, I've got a few questions just before I let you proceed. Have you previously been diverted in the last 5 years?
No.
Do you have any felony convictions in the past 10 years?
No.
Are you currently on probation?
No.
You understand, if you complete the pretrial diversions, the charges will be dismissed, pretrial diverted. However, if you do not fully complete diversion, you will be brought back before the court. If I revoke your diversion, and schedule a sentencing, and you will be a convicted felon, and the future felony convictions or pleas could be enhanced. Do you understand that?
Yes.
Okay, y'all step to the left, please. Who's going to present the Commonwealth's recommendation? Mr. Stockton.
Yes, Your Honor. Miss Branham will plead guilty possession of controlled substance first degree, receive a sentence of 3 years, pretrial diverted for 5 years. She'll also plead guilty to no insurance, failure to maintain insurance, $500 fine plus costs, with a court cost discretion of the court, and be evaluated by the social service clinician, follow all recommendations, obtain and maintain gainful employment.
Okay, what did the court cost this case? Is there a DUI involved in it? Okay, you're gonna need some time to pay that fine. I'll let you pay it at $40 a month. The first payment is 30 days from today. Now, is that what you agreed to, what Mr. Stockton went over? Okay. Now, is anyone included, you are pleading guilty because you are guilty and for no other reason? Knowing your constitutional rights, it explains it's still your desire to give up those rights, enter guilty plea, and allow the court to fix your punishment. Is that your signature on there?
Yes.
I'll accept the agreement, sign the diversion order. You'll need to meet with the probation parole officer over there. Donnie Branham. Commonwealth versus Donnie Branham, 18 CR 0069, and which is a probation revocation, and 22 CR 0078, which is an arraignment. It says, I thought he was arraigned last time. He wasn't. Okay. Okay, the grand jury of Cumberland County has returned an indictment. You have a right to remain silent. Charge you possession of controlled substance in first degree, possession of controlled substance in the third degree, possession of controlled substance not in the original container. Operating motor vehicle under the influence. Beware of seatmate. Mr. Bailiff. Mr. Cross, you acknowledge the identity of your client, receive indictment, await formal reading and arraignment, or plead not guilty, reserving all pre-trial motions.
Yes, Your Honor.
What about it, Mr. Stockton?
Your Honor, we need, now that he's arraigned, I'd ask him to set on the negotiation day for the 14th.
Negotiation date is October 14th at 9 a.m. Your next court date is October 27th, 9 a.m. Both of those are conditions of your bond.
Yes, Your Honor. What's his condition for that?
Come back up here just a second.
If you got a DUI, what was going
Is that
to
a DUI first, is it? Well, he's under, are you working?
Yes, sir.
Where you work at?
Knox Stockton.
Okay.
He reports he's working every day in the logwoods when the
Well,
weather permits. And the mill is not.
I'd say I'm gonna just let the normal restrictions, you got church, work, or a doctor.
He's got an ankle monitor at this point in time.
Yeah, well, I'm worried about him drinking and driving, so don't be around the alcohol. Alcohol consumption, drug consumption is part of your bond, okay? Benjamin Birchfield.
Thank you.
Benjamin Birchfield.
That's a motion to vote. We'll have to get him in NCIC.
Okay, he's not present. Is there a warrant out for him now, or
He never reported.
is there a warrant out? Okay. Shelley Crabtree. Commonwealth Kentucky versus Shelley Crabtree, 22 CR 0068. Are you Shelley Crabtree? Were you born in 1972?
Yes,
What's the last 4 digits social security number?
6623.
Okay. You're here today on a pre-trial conference. What do you have?
We continued this in the last month. Drug court, that's been done, so we go ahead and do it. So,
You're gonna be a pretrial diversion or a
Yes.
felony plea?
I don't know that she knows what day orientation is yet, because she was just accepted today.
The motion has been tendered that says you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes.
Are you the same person named in indictment number 22 CR 0068?
Yes, sir.
Is your judgment impaired today?
No.
Anyway, have you discussed these charges with your attorney? Are you satisfied with her advice?
Yes.
Have you reviewed the evidence Commonwealth has against you, and you believe you're fully informed about your case?
Yes.
You understand that you do not have to plead guilty. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights.
Yes, sir.
You have a right not to testify against yourself. No one can make you say anything. You have a right to speed trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor. The right to appeal this matter to higher court if you lose, the right to require the Commonwealth prove beyond a reasonable doubt that you're guilty of the charge against you. You understand by entering this plea today, you give up all those rights. You
Yes,
understand
sir.
that? I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I do not have to accept the recommendation. In the event that I do not accept the recommendation, the Commonwealth decide to impose a harsher sentence. You have the right to withdraw your plea and go to trial. Now, I've got a few questions to check qualifications for a diversion, okay? Have you previously been diverted in the last 5 years? Have you?
Have I what?
Have you previously been pretrial diverted in the
No.
last 5 years? Do you have any felonies in the past 10 years?
No.
Are you currently on probation? You understand that if you fully complete the diversion agreement, the charges will be dismissed, pretrial diverted. You can get your case expunged. You understand that? You understand if you do not complete the diversion, you will call back before the court, revoked, and a pre-sentence investigation will be done. You'll be a convicted felon after your sentence. You understand that? Move to the left, please. Who's going to present the Commonwealth's recommendation?
Your Honor, Ms. Crabtree agrees to plead guilty possession of controlled substance, first degree, 3-year sentence, pretrial diverted for 5. She'll enter and complete the Cumberland County Specialty Court Program, pay court costs discretion of the court, obtain and maintain gainful employment, and all evidence in this case be destroyed.
Is that what you agreed to, young lady?
Yes.
What's the court cost? $240. I'll let you pay that at $30 a month, starting 30 days from today. Okay. Is that your signature on the document?
Yes, sir.
Are you pleading guilty because you are guilty and for no other reason?
Yes, sir.
I will accept the plea agreement. And you're waiving your constitutional rights, allowing me to oppose it. Sentence. Okay,
Thank you, Laura. Thank you.
great. Thank you very much. Lonnie Duval.
Robert, we have a motion to subtract from that. I don't know if we're wanting to do it now or.
Sure. Wait just a second. You're on the line. On the motion, the Commonwealth case is dismissed. Billy Farley. Commonwealth versus Billy Farley, 22 CR 0075. You are Billy Farley, born in 1974. Pull your mask up over your nose there, if you will. Last four digits, social security number 4246.
Yes, sir.
What do we have in this case? Y'all move to the left.
This is a flagrant non-support case. Mr. Farley's paid a considerable amount. I'd ask it be set for the negotiation day and pretrial for next time. See what we're saying.
Negotiation day is on October the 14th at 9 a.m. You'll be here to negotiate with the Commonwealth. The next court date's October 27th. Both of them are conditioned to your bond, okay? Okay, Dylan Gilbert. Commonwealth versus Dylan Gilbert, 22 CR 0077. Are you Dylan Gilbert? You born in 1999. Last four digits, social security number 2080. Here for pretrial conference, what does the Commonwealth have to say? Is it a felony plea or a
Pretrial diversion.
pretrial diversion? Okay. Mr. Gilbert, I've been informed that you wish to enter a plea today. Is that correct? Are you currently under the influence of drugs or alcohol? Is this plea freely and voluntarily given? Is this plea freely and voluntarily given?
Maybe more towards the mic, it's not picking up.
Listen, you don't have to speak up. These are voice activated microphones. Okay. Are you the same person named in indictment number 22 CR 0077?
Yes.
Is your judgment impaired to any day in any way? Okay, have you discussed this matter with your attorney and are you satisfied with her advice?
Yes.
Have you reviewed the evidence the Commonwealth has against you? Do you believe you're fully informed?
Yes.
You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights. I'm going to go over the rights. At the end, I'm going to ask you if you understand them. You have a right not to testify against yourself. No one can make you say anything. Oh. You have a right to speed trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to higher court if you lose, the right to file a Commonwealth if you want a reasonable doubt that you go through further. You understand me entering this plea today, you give up those rights. You understand that? Yeah, you understand that? You understand that?
Yes.
Okay. I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I do not have to accept it. In the event that I do not accept the recommendation and decide to impose a harsher sentence, you have a right to withdraw your plea and go to trial. Do you understand that?
Yes.
I've got some certain questions I have to ask you to see if you're qualified for a pretrial diversion. Have you previously been diverted in the last 5 years?
No.
You have any felony convictions in the last 10 years?
No.
Are you currently on probation? You understand that if you complete the diversion agreement, the charges will be dismissed pre-trial diversion, you get them expunged. You understand that?
Yes.
You understand that if you do not fully complete the diversion, you be brought back in front of the court and schedule a sentencing hearing if I revoke your pre-trial diversion. You understand that?
Yes.
At that point, you'd be a convicted felon and this conviction can be used against you in the future. The persistent felony offender law. You understand that?
Yes.
Step to your left, please. Ms. Gordon Anderson, will you give us what the Commonwealth's recommendation?
Yes, upon a plea of guilty to possession of a controlled substance, first degree, the defendant shall receive a sentence of 3 years, pretrial diverted for 5 years. Probation is to be supervised. Upon a plea of guilty of operating a motor vehicle with alcohol concentration over or above 0.08 or while under the influence of alcohol or other substances, second offense, the defendant shall serve 7 days and pay a fine of $350 plus court costs. The defendant shall receive credit for time served. The defendant agrees to be assessed by the social services clinician and will follow any and all recommendations. The defendant shall pay fine and court costs at the discretion of the court, shall obtain gainful employment or do 30 hours per week of community service until gainful employment is obtained. The defendant will agree to have any and all drug paraphernalia and contraband disposed of in accordance with the law of the Commonwealth and shall remain on active supervision until any and all fines and court costs are paid in full and until further request of probation and parole.
there was a DUI involved in the plea, then you understand that DUI is enhanceable too, in addition to a felony plea. You understand that?
Yes.
Get another DUI, the penalties will be more severe. Correct? Okay. Now, are you entering a guilty plea because you did do the actions that you're charged with?
Yeah.
Can hear you.
Yes.
Okay. Okay, the fine and court costs are what? $1,000. You need some time to pay that.
Yes.
I'll let you start paying that at $50 a month, starting 30 days from today. Does he have his 7 days in?
Yes, Your Honor.
Okay. Okay, well, I'll accept the plea and sign all the documents. Is that your signature on the documents? And Madam Clerk, is it they complete all of the UI documents?
We have one. Mhm.
Okay, I'll go ahead and sign the situation. You'll need to go there and meet with probation and parole.
And you said $50 per month, correct, Your Honor?
$50 per month, yes. Starting 30 days from today. Ryan Hawkins. Cromwell versus Brian Hawkins. 22 CR 0072. You're here for sentencing, Mr. Hawkins.
Yes, sir.
Correct. What's your year of birth?
32969.
What's the last four digits of social security number?
Sorry.
Is there any reason why this gentleman should not be sentenced today?
No, Your Honor.
Don't plead guilty to possession of controlled substance, the defendant shall receive a sentence of 3 years, serve 90 days in home incarceration, balance probated for 5 years, probation and supervised. What are the court costs in this case?
$240.
$240. You need some time to pay that?
Yes, sir.
You start paying it at $40 a month. First payment's 30 days from today.
Yes, sir.
All drug paraphernalia, any everything's confiscated, will be disposed of. Okay, you need to meet with a probation control officer over there.
Thank you, sir.
Thank you, Your Honor.
James Hurst. Come over as James Hurst.
Yes, sir.
What's your year of birth?
2770.
And the last four digits, social security number.
2119.
We're on a pretrial conference on these two cases. What's the Commonwealth have? Okay. Mr. Hurst, I understand that you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol? No. Is this plea freely and voluntarily given?
Yes.
Are you the same person named in indictment number 22 CR 0013 and 22 CR 0038?
Yes, sir.
Have you had plenty of time to discuss this matter with your attorney? Are you satisfied with her advice?
Yes.
Have you reviewed the evidence the Commonwealth has against you and you feel like you're fully informed about your case?
Yes, sir.
You understand that you do not have to enter a guilty plea today. You have certain rights under Kentucky and the United States Constitution. Prior to accepting a plea, I'm going to go over those rights with you. At the end, I'm going to ask you if you understand them. You have a right not to testify against yourself. No one can make you say anything. You have a right to speak trial with jury after you're represented by an attorney at your jury trial. You have a right to confront and cross-examine all witnesses called to testify against you. Your right to use evidence, or right to call witnesses because we have process issue with fellow attendants. You have a right to appeal this matter to higher court if you lose, and a right to apply the Commonwealth if you have a reasonable doubt that you're guilty of charges against you. You understand that by entering a guilty plea, you give up those rights.
Yes, sir.
Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided law. I do not have to accept the recommendation. Prior to accepting your recommendation, I will await the pre-sentence investigation report from probation and parole. In the event that I do not accept the recommendation and decide to impose a harsher sentence, I will inform you and your attorney of such, and you can withdraw your plea and proceed to trial. You understand that?
Yes, sir.
Y'all step to your left, please. Ms. Gordon Anderson, what is the Commonwealth's recommendation?
Upon a plea of guilty to trafficking in a controlled substance first degree greater than 2 grams of methamphetamine in case number 22 CR 38, the defendant shall receive a sentence of 5 years. Upon a plea of guilty to theft by unlawful taking over $1,000 in case number 22 CR 13, the defendant shall receive a sentence of 5 years. These two sentences are to run concurrently for a total of 5 years, probated for 5 years. Probation is to be supervised. Defendant agrees to pay $3,500 to Elizabeth Ramel at a rate of $100 per month payable to the Cumberland Circuit Court Clerk. First payment being due within 30 days from the entry of this plea and due on the first day of each month thereafter until paid in full. Defendant shall pay court costs at the discretion of the court, shall obtain gainful employment or do 30 hours per week of community service until gainful employment is attained. Agrees to have any and all drug paraphernalia and contraband disposed of in accordance with the law of the Commonwealth of Kentucky, and shall remain on active supervision until all restitution and court costs are paid in full and until further request of probation and parole.
What is court costs? Do what? Yeah, I'm gonna merge the court costs in both cases. $300, do you need some time to pay that?
Yeah, a couple of weeks.
Well, I'm gonna give you more than that. You can pay it in a couple weeks if you want to. You can start paying it at $40 a month, starting 30 days from today, or you can prepay it anytime before then, okay?
Yes, sir.
It'll be in addition to your restitution. Now, you realize that if you ever have another felony plea or guilty plea, that this could be used against you under persistent felony offender law. Do you understand that?
Yes, sir.
Knowing your constitutional rights and considering the offers, it's still your desire to proceed and allow the court to fix your punishment.
Yes.
Okay, I will order a pre-sentence investigation report done by probation, to be done by probation and parole. And you come back here next month for sentencing, which will be on October the 27th. You remain free on bond until, and you need to go over and meet with the probation and parole officer. You got his plea document there?
Yes, sir.
Is that your signature on there, sir?
Yes, sir.
Mr. Bailiff, you'll recover that and give it to them. And you got a signature on a restitution agreement there also?
Put your signature on the
Yes,
restitution.
Yeah, okay, we'll meet with the probation parole officer. Thank you.
Thank you, Ronald.
Caitlin Lawson. Commonwealth versus Caitlin Lawson.
Your Honor, I have accepted this as an appointment with the DPA. This is the first time that I've met Ms. Lawson.
Wait just a second, let me get her in front of you first.
Okay.
Commonwealth versus Caitlin Lawson, 22 CR 0060. Ms. Lawson, were you born in 2000?
You're fine.
You what?
Yes,
The last 4 digits social security number or what?
0818.
Okay. Now, you're newly appointed, Mr. Poindexter.
Yes, sir.
Well, what does the Commonwealth have to say about this?
Yeah, she's among
Have y'all moved to your left, Mr. Poindexter?
4 or 5 co-defendants with Denzel Burton, William Burton, Tammy Weaver, and Dylan Weaver. 5 co-defendants in this case. I just asked that, I think they all have counsel now, set them for October the 14th and the 20th.
October 14th for negotiation and October 27th. Now, we do have a problem here. Ms. Lawson's person, when her bond has decided to go off the bond. What was the bond? Could you look at the file there? Did you have somebody else to go on your bond?
Not sure.
Well, I'm not sure.
Come back to court.
Yeah. Probably.
Who's on the bond? It's a bond person here. Stand up, sir. What's your name? And you want off the bond? Okay. You're released.
Your Honor, do we know, have there been any violations of a bond that the court or anybody's aware of? If not, I would ask for an ROR.
What's the charge here?
It's tracking over 2 grams. I'm also unsure about the amount, but we still don't have the amount.
But it's not based on a transaction, it's based on the
No, it's
amount.
based on possession in the car, like I said, it's 5 people in the car. And 3 of the people, the 5 have bad criminal histories. Miss Lawson does. So,
Where do you live, Miss Lawson?
Thoughtful.
You have any objection to ROR on her?
well, if where she lives and she's got a job, I don't know anything about her other than criminal.
Are you working anywhere?
I just started at a daycare in Scottsville.
With whom do you live? By yourself or with somebody else?
With somebody else.
Is it one of the defendants here? Is this I mean, you have a boyfriend or a husband or a parent or what is it?
No, I'm my mom.
Living with your mom? Okay, well, I'm gonna let you sign your own bond. Okay, and I think I'll keep it a $15,000 surety bond and let you sign it yourself. A bond, it won't be a surety bond, but let you sign it yourself. You're under a curfew. You can go to work, church, or the doctor. If you go anywhere else, you need to call pretrial. And you can get that information. Will they give her that information downstairs? If we go downstairs and sign the bond. You'll be here for negotiations on October 14th at 9 a.m. and back here in court on October 27th at 9 a.m. Both of those are conditions of your bond. Okay?
Thank you, Your Honor.
Okay. Jared Norris. Jared Norris. Wait, what, Mr. Poindexter? Never mind. Yeah, I see what. Okay. Commonwealth versus Jared Norris,
Morning, Your Honor.
20 CR 0069. Mr. Norris, were you born in 1986?
Yes.
Last 4 digits, social security number 8168.
Yes.
You're here today for sentencing. Do you understand that? Have you had an opportunity to look at the
I have.
for pre-sentence investigation report? Pre-sentence investigation report on probation parole. Is it substantially correct?
The only thing that appears to be incorrect, Your Honor, is his jail credit. He doesn't look like he's currently being given any credit for the time that he spent on ankle monitor, and he was on there for almost a year and a half, Your Honor.
You agree with that? Well, if you'll get documentation of that, and give it to probation parole. Okay. Is there any other reason why this gentleman should not be sentenced?
No, Your Honor.
On plea of guilty, receiving stolen property, 3 counts, defendant shall receive a sentence of 5 years on each charge run concurrently for 5 years. On plea of possession of controlled substance, first degree, shall receive a sentence of 3 years. The 2 sentences shall run concurrently, a total of 5 years. Probation to be supervised and agrees to follow all of the recommendations by clinicians. What's the court cost us here? $240. I'll allow you to pay that $40 a month. First payment due 30 days from today, okay? Need to meet with the probation parole officer.
Thank you.
Okay. Robert Purdue. Commonwealth Kentucky versus Robert Purdue, 22 CR 0046. Are you Robert Purdue? Are you Robert Purdue?
Yes.
Are you Robert Purdue?
Yes, sir.
Okay, were you born in 1963?
1963.
Yes, sir.
Give him the hearing device.
Mayor's ring.
Are those working? Can you hear better now?
Sir.
Can you hear better now?
I think he could hear pretty good.
Mayor's ring.
If we speak up, Your Honor, so. Maybe we can all use your outside voice, if you say.
Were you born in 1963?
Yes, sir.
What are the last four digits of your social security number?
3514.
Okay, you're here today on a pretrial conference. What does the Commonwealth have to say?
Your Honor, we have a pre-trial diversion with a DUI.
DUI and a pretrial diversion. Okay. Mr. Purdue, a motion has been tendered that says you wish to enter a guilty plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Sir?
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person indicted in case number 22 CR 0046?
Are you the same person indicted in
Oh, yes.
22 CR 46?
Have you discussed these charges with your attorney and are you satisfied with his advice?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you and you believe you're fully informed about the case?
Sure.
You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights. You have the right not to testify against yourself. No one can make you say anything. Your right to be speed trial by jury. The right to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you. The right to produce evidence. The right to call witnesses in your favor. The right to have this matter taken to a higher court if you lose, and the right to provide the Commonwealth to prove beyond a reasonable doubt that you're guilty of the charge. You understand that by entering a guilty plea today, you give up those rights. You understand that?
Yes, sir.
Okay. Now, have you previously been diverted in the last 5 years? Have you had a pretrial diversion in the last 5 years?
No, sir.
Have you had any felonies in the past 10 years?
No, sir.
Are you currently on probation?
No, sir.
You understand that if you fully complete the diversion program, those charges will be dismissed as felonies, not the DUI, but the felonies, right?
Yeah.
Okay. You understand if you do not complete the diversion and are brought back in front of the court on a violation, I'll order a pre-sentence investigation report. You'll be a convicted felon and that can be used against you in the future. Do you understand that?
Yes.
Okay. You understand that if you plead guilty to a DUI, they're enhanceable and that future DUIs would be at a greater risk or greater penalty. Do you understand that?
Yes, sir.
Can we stand to the left? Who's presenting? Stand to the left. Move to the left.
On this one.
Your Honor, Mr. Purdue agrees to plead guilty to possession of controlled substance, first degree, receive a sentence of 3 years, pretrial diverted for 5, supervised. He will also plead guilty to operating a motor vehicle while impaired, first offense, pay a fine of $200 fine plus costs. He'll be referred to the SSC following all recommendations, receive credit for time served, pay court costs at discretion of the court, and maintain gainful employment.
What is the court cost? Fines together. $850. You need some time to pay that? Move back over here.
850, Robert.
Move back over here. Move back over here. It's $850. You need some time? I'll let you pay it at $50 a month, okay?
We need some time, yes, sir.
$50 a month. Is that okay?
Okay.
Okay, you make your first payment after 30 days from today. Is that your signature on the plea agreement?
Get your signature there, Robert, on all these documents.
Yes, it is.
Hey, Mr. Bailiff, you'll get
No
those,
insurance is not in there anymore. Yeah.
okay? Pull your mask back up, sir. Okay, I'll accept the plea agreement. You meet with the probation parole officer over there, okay? Stacy Shelley. Stacy Shelley. Commonwealth versus Stacy Shelley, 21 CR 00156. Are you Stacy Shelley?
Yes, sir.
Okay, were you born in 1981?
Yes.
What are the last four digits of your social security number?
3557.
You're here on a pretrial conference. What do you have?
Had some difficulty on, I don't know if you're ready to enter the plea or not.
Yeah.
You have a diversion plea now.
What was the problem we had last time? Well, didn't do you get approached around here very much. I understand what you, was it, there's no DUI involved in
No.
this.
Well, if that's what you want to do, the drug court, if that's what we do. I mean, it's just, she did it years ago. Yeah, I mean, she graduated once.
Yeah.
But we just want to do a diversion, but it's whatever you want to do. Want to satisfy you, Mr. Felton?
Do what now?
The paperwork has been changed. I thought she was going to, but Mr. Murphy'd already assessed it, you know. And it's been some time since then. We need to change the paperwork.
Go to put her in drug court?
Yeah, or.
I think she needs to go out. I think she needs a structure.
Well, change the paperwork.
Let's have a seat.
Call it back up. Dylan Weaver. Caldwell versus Dylan Weaver. Now, is the Tammy Weaver case unassociated?
Yes, Your Honor, they're part of that codependent case and I am their mother and son. I'm keeping the Weaver case, so they will not.
Well, you're keeping both of them?
Yes, Your Honor, we've executed the waiver.
Commonwealth versus Dylan Weaver, 22 CR 0065, and Tammy Weaver, we might as well come on up. 22 CR 0073. Are you Tammy Weaver?
Yes, sir.
And you are Dylan Weaver. Now, are y'all gonna come back? This is 22 CR 0065 for Dylan and 22 CR 0073 for Tammy Weaver. Are you gonna come have me on the negotiation date?
Yes, Your Honor.
Be here at 9 a.m. on October 14th for negotiation. Next court date's October 27th at 9 a.m. and both of those are conditions of your bond. Both of you drug-free today if you got tested. A little hesitant there. I'm gonna tell you, subject to being tested anytime. I'm in a really good mood today, or I would have both of you pee in a bottle, because I don't think that you, I mean, you looked a little dazed a little bit to me, but might be because you got black robe syndrome or something like that, like you go to the doctor and your blood pressure goes up. You're gonna have to come off anything you're doing. And just be prepared when you come back here 30 days and from today, if you can't pass a P test, you're going to jail. Both of you understand that? Okay. Thank you. Trey Wright. Trey Wright. Commonwealth versus Trey Wright. 22 CR 0076. Are you Trey Wright? Are you Trey Wright? Okay. You were born in 2002. Last four digits social security number is 9817. Is that correct? You're on 22 CR 0076. What do you got in this thing?
Your Honor, we are still negotiating Mr. Wright's case. We think we can get everything situated at the next settlement conference. We're going to execute a restitution order today. He's got $300 to pay towards this. And I did want to point something out for him, Your Honor. Last time we were here at his arraignment, you had informed him that based on these charges, it would be very good if he came back with a job. And he did, Your Honor. He had orientation on 9/16 and has started working at the NEMAC plant, Your Honor, in Glasgow. So
That's good. Good start. We'll see you negotiation day on the 14th. Is that correct?
yes, Your Honor.
At 9 a.m. and next court date on the 27th. Both of them are conditions of your bond.
Thank you, Your Honor.
Okay, let's go to Allen County, please. Allen County. Allen County on the line. Okay, let's go to Taylor County since Taylor County.
Yes, Your Honor, we have term costs on the way.
Current cost, okay, thank you so much.
Yes, sir, thank you.
Allen County, if you're on the line, you will be next.
All the way.
It's Commonwealth versus current cost.
Turn on the way.
Could you check with Allen County? They don't seem to be on the line.
Apologies, Your Honor, he's on the way.
Okay, thank you. Hello. Commonwealth versus current cost, 21 CR 0005. Are you current cost? Are you current cost?
Yes, sir.
You were born in 1998? Were you born in 1998, Mr. Cost?
Yes, sir.
Last four digits, your social security number 4693.
Yes, sir.
Okay, we're here on a probation revocation. What does the Commonwealth have to say?
Your Honor, I got a report from a Chris Williamson that he hadn't been reporting for about 30 days, but I don't see Mr. Williamson or anybody else on the line to testify. I talked to Mr. Garner about it yesterday.
Your Honor, I spoke to Mr. Cost yesterday, and he indicated that he was going to be hiring private counsel. He has revocation actions in Taylor and Warren as well. And so he was trying to hire a single lawyer for all of those cases. He didn't realize that he had Cumberland County today. When I spoke to Mr. Cost
Well, I'll
yesterday.
continue his case to October the 27th and put a hold on him till then.
Thank you.
Okay, and if it's Mr. Cost, if you get a private attorney, have him contact the Commonwealth Attorney's Office and see if you can roll all these things up into one, okay? Okay, thank you very much. We have nothing else at Taylor County. Thank you for your cooperation.
Okay, thank you, Your Honor. Thank you. Have a good day.
You too. I guess we can go to, we have Grayson County on the line. I don't guess so. Okay, how about Roder? Do we have Roder? Roder is in person. Okay, take the Zoom off that. Let's go to Adair County. Adair County Detention Center. Okay, Commonwealth versus Denzel Burton. Commonwealth versus Denzel Burton. Are you Denzel Burton, sir?
Yes, sir.
22 CR 0058, Mr. Burton. You born in 1971.
Yes,
What are the last four digits of your social security number, sir?
1609.
Okay, your attorney is on the record here. Allen County, I'll be right to you. If you'll turn your camera off just for a second. You just got one case and I'll be right with you. I'll come to you next, okay? Okay, what do you have here, Mr. Stockton?
He's one of the 5 co-defendants in that case, Your Honor. I just need the October 14th and 27th date. I don't know who's representing him though.
Who's
Patrick Lanham, Your Honor, is going to be representing the Burtons. He could not be here today. He took the case on Tuesday, so he was
So that would be Denzel and William both?
Yes, Your Honor.
Is William there too?
Yes,
With
he
you?
is. Yeah,
So William, you get on camera there too, both of you?
yeah, he's coming up here.
22 CR 0059. Gentlemen, you've just been appointed an attorney. They'll be over to talk to you. And we'll have, you're gonna be ready for, he'll be ready for negotiations on the 14th. For the
I think so, yeah.
the negotiation day for him on October 14th, and the next court appearance is October 27th. What's the bond amount in this case, Mr. Stockton?
Oh, no, but it should be pretty high because he's got,
Well, when your new attorney takes a look at the bond, for both of you, he can contact Commonwealth Attorney's Office, see if we can talk about your bond, okay?
And
we
Your
can-
Honor, on that note, William Burton had asked about a long-term treatment. The bed expired. I'm gonna send all the stuff that I have to his new attorney. So his new attorney can, I believe he'll have a bed available. The letter had just expired. So I'll send that to his new attorney, and his new attorney will talk to Mr. Stockton about that.
Well, since there's been some delay in getting your new attorney appointed, when Mr. Stockton, when the attorney contacts you, then feel free to call my office and we'll do a conference to see if we can't take a look at what these gentlemen, what their bonds are and what kind of treatment.
That's fine, Your Honor.
Situation. Okay, thank y'all very much. Now I'm just for a second, I'm going to go over to Allen County. And I'll be right back to there. Commonwealth versus Mary Williamson in Allen County. If you'll turn your camera back on.
I'm trying, Your Honor. For some reason it's got me.
There you go. Commonwealth versus Mary Williamson. Are you Mary Williamson?
Yes, sir.
Okay, this is 22 CR 0063. Grayson County, I'll be with you next, okay? 22 CR 0063. Miss Williamson, were you born in 1999?
Yes, sir.
Last four digits of your social security number 4830.
Yes, sir.
We're here today on a pretrial conference. Ms. Costello, what do you have in this case?
That I'm muted. Sorry.
Your Honor, I was going to, her co-defendant, Stephen Cape, pled. He took 3 years along with another 10 years he had at Russell County. And I told, as part of that agreement, I agreed to dismiss against Miss Williamson if that's all right with the court.
Yeah, you have other charges keeping you in Allen County, Miss Williamson?
Yes, sir. I'm on a serve out.
Okay. Will you have any objection if I dismiss this case against you?
No, sir.
That's the correct answer. If you'd said, yes, I have objections, I was going to order a psychiatric evaluation.
Right.
Yeah, okay. Well, I hope things turn around for you.
Okay.
You're still a young person. You can still have a productive life. Good luck. I hope I don't see you again, okay?
Okay. Thank you so much.
Okay, thank you, Allen County.
Thank you, Your Honor. I'm sorry about being late.
No problem. You have a great day. Grayson County, let's go here real quickly. Grayson County.
Your Honor, we represent Mr. Castillo, and we've been trying to reach him by phone this morning, and we couldn't, they wouldn't let us talk to him. So Mr. Caldwell's trying to talk to him now about what we need to do in this case.
Well, there's two cases over there. I'll take the other one first. Grayson County. Commonwealth versus April Nethery. Are you April Nethery?
Yes, sir.
Okay, this is 22 CR 0066 and 21 CR 0031. Miss Nethery, were you born in 1981?
Yes, sir.
Last four digits of social security number 5139.
Yes, sir.
Okay, what do we got here, Mr. Stockton?
Miss Costello wasn't able to talk to Miss Nethery because they moved her from a different jail, so we need another negotiation day.
Yes, Your Honor. We did a transport order from the Adair County Jail, but she had been moved to Grayson County. It looks like she'll be served out on in Grayson County October 1st, so she should be moved back to Adair County for the next settlement conference, so.
Okay, October 14th for a settlement conference at 9 a.m., October the 27th at 9 a.m. for the next court hearing. Ms. Neely, both of them are conditions of your bond. And you heard what they said, that you'll probably be transported back to Adair County Court. Okay, well, thank you very much.
Your Honor, one of her cases, she's still being held on no bond. She has a cash bond on the other case. We would just ask that there
I
be,
don't know enough, I don't know enough about them to make a decision right now. If you want to contact the Commonwealth about that, I'd be glad to get you on the record some time other than right now, okay?
Okay.
If you can't reach agreement. There's Mr. Costello, Commonwealth versus Nathan Costello, 21 CR 0009. You are Nathan Costello.
Yes, sir.
Okay, and you born in 1981.
Yes, sir.
Last four digits of your social security number are 3232. If you want to go back there and use it,
Mr. Caldwell is, we have spoken to him, so Mr. Caldwell's getting on the.
what do you have, Mr. Stockton?
My understanding from talking to Mr. Cross was that Mr. Castillo was going to stipulate the competency and the revocation, Your Honor.
That's correct, Your Honor.
Okay.
Nathan,
Yes, I am competent to stand trial.
Yeah, is there is this just a revocation?
It is, Your Honor.
Okay, well, if he stipulates competency, we'll go ahead. And he stipulates a violation for revocation. Is that right, counsel?
Yes,
Counsel, is that correct?
yes,
Okay, well, I'll go ahead and sign the order. Thank you very much. Grayson County, I guess that concludes our business. You can be released. Thank you for your cooperation. Let's go back to Adair County. Commonwealth versus Sherry Coote, is that correct?
Cody,
Yeah.
Cody, yes.
Okay, Grayson County, you can turn your cameras off. Thank you. Sherry Cody, 20 CR 0041. Are you Sherry Cody?
Yes, sir.
Who's got the master on this intern, Grayson? Megan, will you turn the other Grayson County camera off, please? Thank you so much. Okay, there it goes. We're here on 20 CR 0041, a diversion revocation. Mr. Poindexter represents this lady, is that correct?
He does, Your Honor.
He did what? He's not here.
He informed me this morning he was still representing.
Where is it? Well, what does that mean to me? Miss Megan, did he say he couldn't be here? He was here earlier.
No, he said he was gonna be a little late this morning, but he was here by the time you called his first name.
Okay, well, I'll pass over her case then and come back to it. Melissa Harris.
Your way.
Megan, could you hand someone a drink for me back out here, please? Commonwealth Kentucky versus Melissa Harris. Are you Melissa Harris?
Yes, sir.
Were you born in 1969?
Yes, sir.
Okay, last four digits, social security number 8326.
Yes, sir.
Round 12, CR 0031. Shock probation revocation. What do you have, Mr. Stockton?
Your Honor, Miss Harris was originally probated on a criminal mischief and wanton endangerment case, got a 3-year sentence. She was supposed to pay about $4,100 restitution, and she absconded. And then I found out she served 9 months in jail in Florida from September 22nd of 2018 to May 29th, 2019. And she never reported when she got back to Kentucky. So she still owes about $2,400 in restitution, and she's not been supervised for quite some time here in Kentucky.
Your Honor, if I may, I spoke to Miss Harris, and she does stipulate to the failure to report. She would explain to the court what happened, and why that occurred. And she does have a plan for repayment of that restitution now.
Yes, I have employment and have the opportunity to make the payments and get that took care of. When I was released from jail in Florida, I had served it out there and just kind of got stuck in between the COVID and everything else. It just kind of
Where are you gonna be working? Where are you gonna be working?
It's a family business. My sister owns a cleaning company in Campbellsville. That's where I'm originally from. That's where all my children, my grandchildren are.
And that's where she's gonna be residing too.
What were the charges in Florida you served out?
A pawn shop. I pawned a person didn't have an ID and I used my ID and I pawned some jewelry and a TV. And I got myself in a mess over that.
Okay, what do you have to say, Mr. Stockton?
Well, I don't think Miss Harris's credit's very good as far as reporting, but based on the COVID situation and everything, I don't mind giving her a chance, but I think she needs to be under some strict supervision for a while to make sure
What
she
is,
reports.
what's the amount that's owed, 2,400?
2,400 left, and I don't even know it was on the state, so there should be a record of it downstairs. She still have to pay the money in. I think she took a car from the state at the time.
We do have, I'm sorry, we do have paperwork saying that Florida does want her back.
That's not good.
I served this out. They took me there twice.
Okay,
And I've had
what we'll do is,
Because I've got a Department of Corrections warrant from the state of Florida on her.
okay. I'll just order her to pay $100 a month. And,
Yeah, we'll never, once she goes to Florida, Your Honor, we'll never have her back up here again, I don't think.
yeah. Well, I'm gonna go ahead and revoke her shock probation here. That's about the most I can do. I'll just revoke it and we'll decide whether she goes. If I revoke her shock probation, I don't know whether they'll want to take her back before she finishes her term here. And if she does finish her term here, once I revoke the shock probation, Mr. Stockton, don't have another shot at her,
No, but she can file under the Interstate Agreement on Detainers Action, then Florida would have to come and get her while she's serving her sentence. That might be to her benefit. If they don't come and get her, then they won't get
$2,400 back for the.
No, it won't. But the parole board might get it back.
Yeah. No. Okay.
I don't understand.
Okay, here's the thing about it is, they're wanting to take you back to Florida. I can't let you loose anyway. If I did some kind of sanction and told you to pay $100 a month, you pay the $2,400 off. That wouldn't get you out of jail. What Mr. Stockton's saying is if I revoke you and they take you back to Florida, the time you're serving in Florida would count against this time that you're serving up here. We're trying to do something to help you. Okay?
Yeah, because I feel like I've just been in a ping pong with these two states.
I'd say you might have, but you probably hit the ball over the net yourself the first time.
Yes, sir.
Okay, so what I'm going to do is I'm going to revoke the probation. And that way you can, as you take care of your things in Florida, the time will run good for you. And then you can see the parole board pretty quick, okay?
Okay.
Okay, thank you very much.
Failed to report.
How much time will I have on it?
They don't know. This will be your
Okay.
Florida. You failed to report. You was on probation down there, so you didn't report for probation. That's why they have a warrant for you in Florida.
Yeah, what was
Ain't
the
got
sentence
anything
up
to
here,
do with
Mr.
your-
Stockton?
3 years, you're on the
3
deed.
years, and you've got
Yeah.
some of it done. You'll be eligible for parole up here almost immediately from the time you got in. Okay, thank you very
Yes.
much.
Great.
Richard Hawkins. Richard Hawkins.
That's a plea.
You can take it, yeah. But that-
Richard Hawkins. Cumberland versus Richard Hawkins. 22 CR 0024. Are you Richard Hawkins?
Yes, sir.
You born in 1987?
Sure.
Last four digits, your social security number 3452.
Yes, sir.
You're here today on a pre-trial conference. What do you have to say, Mr. Stockton?
We have a plea in this, Your Honor, a felony plea.
Okay, Mr. Hawkins, a motion has been tendered that says you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person named in indictment 22 CR 0024?
Yes.
Is your judgment impaired today in any way?
No, sir.
Have you discussed these charges with your attorney, and are you satisfied with the advice of your attorney?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you? You feel like you're fully informed about your case?
Sir.
You understand you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept the plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. You have a right to speak trial by jury. The right to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you. The right to produce evidence. The right to call witnesses in your favor. The right to appeal this matter to a higher court if you lose. And the right to a part of the Commonwealth prove beyond a reasonable doubt that you're guilty of charges against you. Understand that by entering a guilty plea today that you give up those rights. You understand that? Now, I may consider the Commonwealth's recommendation, but I may find the range of sentence allowed by law. After reviewing the pre-sentence investigation report, if I decide you need a harsher punishment, impose that, you can withdraw your plea and go to a jury trial. You understand that? In other words, I can't give you any more than you're agreeing to. If I say you ought to have a longer sentence, and they're saying you can withdraw your plea and go to a trial. You understand that?
Yes, sir.
Okay. Who's going to present the recommendation to the Commonwealth?
Your Honor, I am. It's he's going to plead guilty possession of a controlled substance, first degree, receive a sentence of 3 years, serve 60 days, balance probated for 5 years, receive credit for time served, probation to be supervised. Also, you'll plead guilty not failure to maintain insurance on a vehicle, be a $500 fine, pay the cost and fine discretion of the court, obtain, maintain gainful employment once he's released, and all evidence in this case will be destroyed.
Is that what you agreed to, sir?
Yes, sir.
Now, I'm going to order a pre-sentence investigation report to be done about probation and parole. You'll be sentenced on the 27th. Will he have his days in by then?
I already do, actually, I do believe.
Already have his days in. Okay, well, we'll see on the 27th. Now, you realize by entering a guilty plea here today, this is a felony plea. If you have any other felonies in the future, this could be used against you. Was there a DUI in this?
No, Your Honor.
Wasn't a DUI, so that's just a regular felony plea. So they could be used against you if you have another felony. You understand that?
Yes.
Okay, got your court costs here. $720 court costs. That's because the insurance. You'll need some time to pay that, I'm sure. So I'll let you have $50 a month starting 30 days after you get out. He already has his time in, Mr. Stockton. Do you have any? Is that correct, Counselor?
I believe so, Your Honor. I counted, but I don't have the official. It was just me looking at CourtNet, so I don't have an official from
Okay, well,
probation.
how many days was he has to serve on this?
60, yeah. If
Have you been
Mr.
in
Garner
60
can verify.
Have you been in 60 days, sir?
Yes, sir.
Okay. We'll have probation parole check to make sure they got the damn. Mr. Garner, can you check to make sure they got the 60 days down on this guy? I'm gonna do something I don't usually do. And that's, I'm gonna go ahead and let you bond out until your sentence. Is there anything else holding you in jail?
No, sir.
Well, do you think can you try to get a job?
Yes, sir.
If I let you out. So what I'm gonna do is I'm gonna have probation and parole go ahead and check that out. I'm gonna sign a document that'll let you out of jail, and you're gonna be back here for your sentencing. When does he need to come meet with probation and parole?
He can come tomorrow at 2 p.m.
It's the Columbia office. Go to the Columbia office. I'm gonna let you out tomorrow at 1 p.m. You go straight over in probation and parole office, okay?
Thank you.
Okay, now, don't let me down on this thing. Go out and get doped up and do anything, because you got a chance at having no more jail time if you act right, okay?
All right, thank you.
Okay, hold up his plea document there. Is that your signature on there, sir?
Yes, sir.
You realize that, as I said before, any future convictions will be enhanced under persistent felony offender law. You understand that because of this plea? Okay, we'll see you here on the 27th of October. I'm gonna send an order up, release you tomorrow, 1 hour before you go to probation parole, go straight over there, okay?
Yes, sir.
Okay, thank you very much.
Thank you.
Kevin Newton next, is that right? Kevin Newton. Commonwealth versus Kevin Newton. It's Commonwealth versus Kevin Newton, 22 CR 0052. Are you Kevin Newton?
Sir.
Born in 1981.
Yes, sir.
Last 4 digits of your social security number 0096. Is that correct?
Yes.
You're on 22 CR 0052 for sentencing. Oh. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
Sir.
Is it essentially correct?
Sir.
Counselor, are you on there? Is there any reason why the gentleman should not be sentenced today?
No, Your Honor.
Okay. And a plea of guilty to traffic and controlled substance, first degree, finish shall receive a sentence of 10 years. Is that correct, Mr. Stockton?
Yes, it is, Your Honor. There's quite a bit of substance.
Okay. I'm gonna, since he's serving that amount of time, I'm gonna waive the court costs.
Thank you, Your Honor.
I'll waive the court costs. Okay, thank you very much. Christopher Toole.
I don't know if there's anybody out there or not. If there ain't, you can just sit in here.
Christopher Toole. That's correct pronunciation. Christopher Toole for,
Go ahead, go back.
is that how you say your name, Christopher Toole?
Yes.
Okay. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
Yes, sir.
Okay, this is 21 CR 0083. You were born in 1978, sir.
Yes, sir.
That's 4 digits, social security number 5822.
Yes, sir.
Okay, counselor, is there any reason this gentleman should not be sentenced today?
No, Your Honor.
On plea of guilty to possession of controlled substance, first degree, he shall receive a sentence of 3 years, probate for 5 years, probation to be supervised, credit for time served. The court costs in this case were what? $210. Did I tell him how he was to pay that? I'll let you pay $30 a month, 30 days from your release. I guess he needs to meet with probation and parole. Is that right, Mr. Garner?
For noon tomorrow.
Noon tomorrow. Has he got his days in?
Yes, Your Honor. He was to be released at sentencing.
Okay. Where do you live, Mr. Toole?
206 East Hill Street, Albany, Kentucky.
Where do you want him to go to meet with?
You live in Albany, Your Honor?
Yeah.
He'll call me, Your Honor. It's immediate transfer. I can just transfer to Albany and report to Albany tomorrow.
Okay, we're gonna, if you'll call a probation and parole number, you'll give him that, Miss Costello. They'll transfer him over to Albany and he'll meet with probation and parole in Albany tomorrow. Mr. Tootle, don't get into anything tonight between the now and then.
Yes,
Did you rather do that, or did you rather stay there tonight and just go ahead and meet tomorrow with them in Columbia? Did you rather go ahead and get out tonight?
Sir.
Okay, well, you stay clean tonight.
Yes, sir.
I'm saying, okay.
Christie,
And
can you,
they'll give you a time to be there tomorrow. I'll send the papers up, okay? Thank you
Christie,
very much.
can you-
Joshua Vibert.
Yes,
will you give him that number, please? Write it
yes, I
down
will.
for him. Thank
Yeah.
you.
You're welcome.
Joshua Vibert.
Yes, sir.
Commonwealth versus Joshua Vibert, 22 CR 0021 and 22 CR 0069. Were you born in 1982, Mr. Vibert?
Sir.
And the last four digits of your social security number is 6690, is that correct?
Yes, sir.
Here today on two cases, 22 CR 0021, 22 CR 0069. You represented by Mr. Cross. What do you have to say, Ms. Gordon Anderson?
We have a felony plea.
Okay. Mr. Vibert, a motion has been tendered that says you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person named in indictments number 22 CR 0021 and 22 CR 0069?
Yes, sir.
Is your judgment impaired in any way today?
No, sir.
Have you discussed this with your attorney, Mr. Cross, and are you satisfied with his advice?
Yes, sir.
You reviewed the evidence the Commonwealth has against you. Are you fully informed about your case? Are you?
Yes, sir.
You know, you do not have to enter guilty plea today. You have certain constitutional rights under Kentucky and United States Constitution. Before I can accept your plea, I need to know that you understand those rights. I'm going to go over the rights here, and after I conclude them, I'm going to ask you if you understand them, okay?
Yes,
You have a
sir.
right not to testify against yourself. No one can make you say anything. Right to speedy trial by jury. Right to be represented by counsel at your jury trial. Right to confront and cross-examine all witnesses called to testify against you. Right to produce evidence. Right to call witnesses in your favor. Right to appeal this matter to higher court if you lose. Right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. You understand that by entering a guilty plea today, you give up all those rights. I may consider the Commonwealth's recommendation, but I may apply any range of sentence permitted by law. I don't have to accept it. Prior to accepting the recommendation, I'll await a pre-sentence investigation report done by probation and parole. In the event I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. Now, Ms. Gordon Anderson, what is the Commonwealth's recommendation?
Yes, Your Honor. Upon a plea of guilty to fleeing or evading the police first degree, 2 counts in case number 22 CR 21, the defendant shall receive a sentence of 4 years on each charge to run concurrently for a total of 4 years. Upon a plea of guilty to tampering with prison monitor device and escape second degree in case number 22 CR 69, the defendant shall receive a sentence of 4 years on each charge to run concurrently for a total of 4 years. The sentence in case number 22 CR 21 and in case number 22 CR 69 are to run consecutively for a total of 8 years, probated for 5 years. Probation is to be supervised. The defendant shall receive 148 days credit for jail time. The defendant shall serve an additional 60 days on home incarceration after he is final sentenced. The defendant shall enter and complete the Cumberland County Specialty Program. The defendant is currently incarcerated and shall remain incarcerated until the morning of his drug court orientation. The defendant shall pay court costs at the discretion of the court. The defendant agrees to have any and all drug paraphernalia and contraband disposed of in accordance with the law of the Commonwealth of Kentucky and shall remain on active supervision until all court costs are paid in full and until further request of probation and parole.
Madam Clerk, what is the court cost?
$255.
$255, and let him do that at $30 a month, starting 30 days after your release. Mr. Vivers, is this what you agreed to?
Yes, sir.
Do you realize that after entering a guilty plea today, these charges can be used against you if you have any additional felonies in the future to enhance your sentence, right? You
I do.
understand that?
Yes, sir.
Now, Ms. Gordon Anderson, were the officers involved consulted and they are in agreement with this?
Yes, Your Honor.
Well, I see no reason not to take your plea. We'll refer it to the probation pro for a pre-sentence investigation report. And, Mr. Cross, you have his papers there. Can you hold the signature up to the camera? Is that your signature on there, sir?
Yes.
Okay. Okay, we'll have you back here on the 27th for sentencing.
And point of
Thank you, sir.
clarification, Your Honor, he's been assessed. I think orientation is tomorrow, so I presume he can be released in the morning.
He will be released if the orientation is complete. Is that right, Ms. Gordon Anderson? There was nothing else holding him. If he goes into,
Honor.
do what? I can't hear. Well, he's gonna have a sentence order today. Oh, he hadn't been sentenced yet. He got the order, okay. He has to be sentenced before he can do the drug court, is what they tell me.
Can we waive PSI then, Your Honor, so we can get him out?
No, we can't waive the PSI. No, so.
And I'm not disputing what the court says, but as I occasionally do, I get confused at times. I understood at times, I recall at times in the past, we have had people begin drug court before their final sentencing.
I'm just. Well, I'm gonna go ahead and enter the order. If there's a deviation from that, he'll be here for sentencing on 27th. And at 9 a.m., okay?
And he'll be released for orientation, correct?
No.
No.
Mr. Murphy, I've got a guy that just entered a plea here that we sent to drug court. I ordered a pre-sentence investigation for it. Well, have to be.
He does not. We do an assessment. And then 27th, we would accept him. And then I'd do orientation after he signs his plea.
Okay.
I couldn't hear anything back there. Oh, I'm sorry.
It says he has to do the assessment after the plea.
No, I do this. Yeah, I can do orientation. I just have to go back to and make sure nothing's changed with him as far as assessment. Once he signs his plea, I can do orientation. So I'm just waiting on him to sign a plea to do orientation. It's been done. Yes, yes. Your signatures on it that he signed the plea, and then I can do orientation.
Well, I haven't signed the judgment.
Okay.
Because I don't sign the judgment until after I get the pre-sentence investigation report done by probation and parole.
Okay. As soon as I get the paperwork, I will do the orientation within 2 days.
Okay, thank you very much. Yeah. Jim A. Webb. Commonwealth versus Jim A. Webb. This is 22 CR 0062 and 21 CR 0017. Are you Jim A. Webb? Okay, it looks like on one of your cases it had DPA, and on the revocation it has Stephen Poindexter
Yes, sir.
Your Honor,
DPA on the-
I spoke to Mr. Webb yesterday, and I believe DPA is handling both of the cases for him.
And you have another case on the docket, though, don't you?
Yes, sir.
Okay, DPA on the line now?
I apologize, Your Honor. It had kicked me off and I had to get back on.
Your Honor, we have a misdemeanor plea in this one, and then I believe he's going to stipulate to the revocation.
Sorry, Your Honor, it kicked me off and then let me back on, and I don't know that it's still working.
Well, we've got it. It's got your signature up. Go back there and hit it again.
Okay.
Can you hear me, Your Honor?
I can hear you. I can't see you. Can you see us?
I can, Your Honor, and I'm showing on my video, so I don't know why.
There you are.
Okay,
There you are. Okay, Mr. Webb has previously identified himself. We're here on a pretrial conference and a probation revocation. Mr. Poindexter is replaced as counsel by the DPA on the 21 CR 0017. What does the Commonwealth have to say, Ms. Gordon Anderson?
Yes, Your Honor, we have a misdemeanor plea, and I believe that Mr. Webb's going to be stipulating to the revocation.
correct, Your Honor.
A motion's been tendered. It says you wish to enter a plea today. Is that correct, Mr. Webb?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and openly voluntarily given?
Yes, sir.
You're the same person that was named in indictment number 22 CR 0062. Is that correct?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you?
I have.
Have you discussed this matter with your attorney? Are you satisfied with her advice?
I am.
Okay, we understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution.
Yes, sir.
Prior to allowing you to enter this plea, I'm gonna go over these rights and I'm gonna ask you if you understand them. Okay, you have a right not to testify against yourself. No one can make you say anything. You have a right to speak trial by jury, right to be represented by counsel at the jury trial, right to confront and cross-examine all witnesses, call testify against you, right to produce evidence, right to call witnesses in your favor, right to appeal this matter to higher court if you lose, and right to require the Commonwealth to prove beyond a reasonable doubt to get guilty of charges against you. Understand that by entering guilty plea today, you give up all its rights. You understand that? And I may consider Commonwealth's recommendation now may apply in range of sentence provided by law. I don't have to accept the recommendation. And could you go ahead and give the recommendation, Ms. Gordon Anderson?
Yes, Your Honor. Upon a plea of guilty to possession of a controlled substance, second degree, the defendant shall receive a sentence of 12 months. The firearms listed in agency case number 22-32 shall be released to their rightful owner if proof can be shown within 30 days from the entry of this plea. The defendant agrees to forfeit his interest in the firearms. The defendant agrees to stipulate to revocation in Cumberland Circuit Court case number 21 CR 17. The defendant shall pay court costs at the discretion of the court, shall obtain gainful employment or do 30 hours per week of community service until gainful employment is obtained. And defendant agrees to have any and all drug paraphernalia and contraband disposed of in accordance with the laws of the Commonwealth of Kentucky. And the defendant shall remain on active supervision until all court costs are paid in full and until further request of probation and parole.
What did the court cost here?
$225.
$225. Explain to me about the firearm.
Your Honor, this was a case where Mr. Webb was found at a barn / shed. He had permission to be at that barn, but there had been several calls to law enforcement that many people had been up there. And given where the firearms were, it's not clear that they were possessed by Mr.
Where
Webb.
were the fires?
There were around the truck and by the shed, Your Honor. But many people had had access. Mr. Webb has a 10-year sentence that he's stipulating to being revoked on. So given the problems in that case, Mr. Stockton agreed to a misdemeanor on this case.
I'll waive the $225 court costs considering the length of the sentence. Is this what you agreed to, sir?
Yes, sir.
Okay, I will sign the misdemeanor judgment on the misdemeanor plea, no PSI is required for that. I'll revoke on 21 CR 0017. Okay, thank you very much. Now, we got to
Your
go back
Honor.
to, yeah.
On this,
Yeah, go ahead.
on this case, we also have a motion to release evidence that was, looks like that was taken into custody for the 21 CR 17 case. And we have a motion to forfeit the guns that were also recovered, as well as
Those are granted.
Okay.
Okay.
Thank you, Your Honor.
Okay, let's go back. Mr. Poindexter had a case that was lingering. Sherry Cody. Where are you, Mr. Poindexter? Why aren't you here?
I came back over to my office since we were doing video, Your Honor.
Okay. Commonwealth versus Sherry Cody, 20 CR 0041. Ms. Cody, you born in 1976.
Yes, Your Honor.
Do you have the last 4 digits, social security number 7839?
Yes, sir.
Okay, we're here on a diversion revocation. What does the Commonwealth have to say?
Your Honor, she has a 3-year sentence on possession. In August of this year, 2nd, she failed a report. She was also positive for methamphetamine on August 15th and September the 6th. I've spoken with her counsel, and I'm recommending, if the court will approve, that she stay incarcerated until she's accepted and enters into the Cumberland County Specialty Court Program.
And I've spoken to Miss Cody, and she has agreed that she wants to do drug court, Your Honor.
Okay, what kind of orders do I have to sign to get her there?
We'll do an order referring her to the drug court and order in lieu of revocation, Your Honor.
Okay, that'll be fine. We'll hold her until then. This will be put down as a kid. I guess, how will she be coded? Is she a state prison?
No, Your Honor.
Okay. How's she coded now as far as being in? There's a certain designation I give it to get her off the county payroll.
Judge, she's a pretrial diversion, so you cannot make her stay inmate with the alternate sentence.
Yes, sir. It's within 7 days.
According to
I
our
thought there
new
was-
protocol, she should be assessed in 7 days. And when
Yeah.
she's assessed, we can just do an order
Yeah.
for releasing her.
I understand she's a pretrial diversion. I was just trying to get her off the county's dime.
Yeah.
At one time, there was a sanction code they put in or something like that. Yeah. Okay, well, she won't be there that long. Guess
Yeah.
Cumberland County can afford it for a few more days. Okay, well, I'll sign the order, referring her over to, drug court and release her to drug court after she gets orientation. Okay?
Thank you, Your Honor.
Thank y'all very much. Now, Miss Megan, is there anything else that's on the docket or the Commonwealth? Y'all know anything else on the docket?
Oh, we had Jonathan Nethery on the docket.
We still
Yeah,
have
he's-
Stacy Shelley.
Yeah, and
Okay.
Stacy Shelley.
Let's call Jonathan Nethery out. He's here in person. Where is Nethery at? Is she in jail somewhere?
Jonathan Nethery's there in
Stacy
person.
Shelley, yeah, Jonathan Nethery's here and Stacy Shelley is present.
Okay.
We'll call Jonathan Nethery to come out first. Okay. Well, where is? We're on the dock of the show. Did I miss that?
No, you called it, but they haven't talked about. And then the grand jury.
Yeah, I'll go right down to it. Cumberland versus Jonathan Nethery, 21 CR 00149. Good morning, Mr. Nethery. We're here. Where is Mr. Cross?
He's already left. He's already left. He'll be back this afternoon. But where he's at now.
You're his associate, aren't you?
Yeah, but I'm not familiar with what's going on or today. All we're asking to do is set up a hearing date, a couple of extra witnesses on his motion. Okay.
Come up, make your presentation.
Yes, Your Honor, after reviewing this case and out of abundance of caution, Mr. Cross originally filed a motion to suppress. We had a hearing. Then he wanted to get the medical records from the hospital. There's a
Let
couple
me
of.
see if I can get Mr. Cross on.
Okay.
You have Mr. Nethery. Did you forget Mr. Nethery?
I forgot Mr. Nethery. Yes.
You're on the speakerphone. Your associate is standing in for you here, but I'm gonna let you be on the speakerphone so you can hear what's going on, okay?
Thank you.
Okay, go ahead. Y'all move to the left here, please. Mr. Stockton, speak up a little bit so I can hear you.
Your Honor, after reviewing this matter, I would like to have an opportunity to take the testimony of the two nurses in the emergency room. Mr. Cross asked the last time, when we got the medical records, whether we was going to do that, and out of abundance of caution and the seriousness of this case, I think we ought to be able to take those witnesses.
Okay, what we're gonna, when you wanna set a date certain?
We need to do a date certain or next month, whatever the court wants to do.
Let's say, let's do it at the next rule day. That'd be the easiest way to schedule you, don't you think, Mr. Cross?
Is this to take additional proof for
Yeah.
Mr. Stockton?
Right, he's gonna take the nurses or any other additional proof he wants to take on that date.
Well, of course, I'm not agreeing to it. I want to get an objection in for the record, but I understand the court's ruling. And yes,
Tell
I'd
me
like to
what
get it
your-
done in one day.
Tell me what your objection is.
Well, Judge, this case, I mean, we've had a hearing long ago, months ago, and our presentation of our part of the case or the limited basis thereof is based on what evidence the Commonwealth put forward or did not put forward on that day. We felt like the matter should have been concluded on that day. And I think it's prejudicial to Mr. Nethery to open it back up because I don't know how
think we ever closed it. The issue, I left it open on that day. See if any additional testimony should be taken. So I'll overrule. You got it on the record now. And we'll be here on October 20th. Back to Rotor. They're not going to stay here for 2 hours, so you can talk to him. Okay. Okay.
I understand.
Okay. Thank you very much.
Is that correct?
I assume that you didn't want to stay around for 2 hours.
I'd rather not.
I should have consulted you on that, so, okay, thank you very much. Oh. You want to talk, you want to explain to him, you can go back here with me, explain to him what just happened, if you don't mind, officer, and that way have an easier trip home, maybe. And what's our other case we have?
That's me as well. Go ahead and take care of this, Ms. Kelly.
Yeah. If you'll just wait a second, let him consult him just for a minute. Ms. Shelley, Stacy Shelley. Now we got a plea on this now, is that right? Did we go over all this a few minutes ago with her? I don't know if we did or not, so.
I was out of the court at the moment. Did they review everything?
Yeah, just go ahead and do the drug court.
Yeah, okay, well, we're on, back on 21 CR 00156. You are Stacy Shelley, you born in 1981. What are the last 4 digits of social security number?
3557.
Now, is this a felony plea, Mr. Stockton, or pretrial diversion? The motion's been tendered to say that you wish to enter a pretrial diversion. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given?
Yes.
Are you the same person named in indictment number 21 CR 00156?
Yes, sir.
Is your judgment impaired today in any way?
No.
Have you discussed these matters with your attorney, and are you satisfied with the advice of your attorney?
Yes, sir.
You have a right not to testify against yourself. Be represented by counsel rather than jury trial. Confront and cross-examine all witnesses called to testify against you. To produce evidence, call witnesses in your favor to appeal this matter. Higher court if you lose and require the Commonwealth to prove on a reasonable doubt that you're guilty charged against you. Understand by entering a guilty plea today, you give up those rights. Now I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. In the event that I do not accept the recommendation of the Commonwealth, you decide to impose a harsher sentence, you have the right to withdraw your plea. Have you previously been pretrial diverted in the last 5 years?
No.
Have you had any felonies in the last 10 years?
No.
Are you currently on probation?
No.
You understand if you successfully complete the diversion, the charges will be dismissed. Pretrial diversion, you have them expunged. Do you understand that?
Yes.
If you don't complete the pretrial diversion, however, you'll be brought back to front of the court, have a pre-sentence investigation report done, you'll be revoked, be a convicted felon that can be used against you in the future. You understand that to enhance sentences. What is the Commonwealth's recommendation? We move to the left there, move to the left.
Your Honor, Ms. Shelley will plead guilty to possession of controlled substance first degree, receive a sentence of 3 years, pretrial diverted for 5 years. She'll enter and complete the Cumberland County Specialty Program, pay court costs at discretion of the court, maintain gainful employment if she's eligible, and agrees that all evidence in this case is destroyed.
Is that what you agreed to?
Yes, sir.
Does anybody threaten or coerce you anywhere? You pleading guilty because you are guilty?
Sorry.
You are pleading guilty because you are guilty. You haven't been threatened or coerced or anything. Okay. Knowing as your constitutional rights, as I've explained to it, is still your desire to enter a plea in this case, allow the court to fix your punishment. Is that your signature on there?
It is, yes, sir.
Okay. Well, I'll accept the agreement to sign the document. You need to go over and make the probation. What are the court costs? $240, and I'll let you pay that at $30 a month, starting 30 days from today to make the probation parole over there. Okay. Thank you very much. Any other matter come before the court? Criminal matter? Okay, I'm gonna go down and meet with the grand jury then. Let's go off the record. What is that?
Reorder of injury when you cross under the on it. So that this.
Well, I had the interview.
actually my idea of what she thinks about. Good, Mr. Cross.
If it's not, we're mad.
No, thanks.
Okay, y'all got anything else?
Well, we submitted the orders in that Brown's case, Christie, Charles Brown, and we should be ready. He must not be on yet. Right.
Wheeler versus Appleby. What we got here?
Your Honor, this is a grandparents visitation case that we filed a motion to enforce the court's prior order. The visitation has commenced. The matter was set for review today. A friend of the court has filed a report. I have spoke to my client. Speaking candidly with the court, Your Honor, as we try to do, the boys do not, at this point in time, wish to have visitation in the home of Ms. Wheeler. It's an adversarial type situation. So I think what we're prepared to do is if the court can establish some parameters for contact and for access to information, we're prepared to convert the visitation to the discretion of the boys. But we do have some requests or motions in regard to access communication.
Okay. You
What we want.
want to set those out, or you want to go back in the back room and try to work them out?
Okay, I can do that, Your Honor.
Which one would you want to do? You want to set them out here, or you want to go back and negotiate them and come back?
We've tried, and
What's the sticking point?
three things we want, Your Honor. Number one, we want notice of every activity the boys have, every extracurricular, which I think that's a reasonable request. Number two is Ms. Wheeler is the grandmother, the mother's dead. She would like access to medical information regarding the boys. And number three is we want some degree of telephone contact being authorized or permitted, or if Ms. Wheeler can come to Burkesville and take the boys to Annie Ruby's to eat or something like that. But we're not going to make them go to Gainesville.
Just for our part, he's agreeable to having open lines of communication between the two of them. We're agreeable to being at the discretion of the boards, agreeable to notice of, I think that's reasonable. I don't think there's any reason she should have access to the child's medical records. She respectfully, she's not a parent. These allegations were investigated by the friend of the court. She filed a lengthy report. Our proposal would be in accordance with what the friend of the court recommended. And I guess that would be our position. The other two, we have no problem. He's happy to facilitate it. I told him to encourage the line of communication.
So it's down to the medical records?
Yes,
I believe so.
I think so, Your Honor, and I think we just need some degree of access.
But I want to also tell him about him.
Ms. Wheeler, I know that's why we're not insisting that they go, but there's not much he can do about that. What my client just stated, Your Honor, we're of the opinion that and there's an allegation on both sides, that these young men, they're twins, they're great big boys now. They have a degree of resentment toward Miss Wheeler, the grandmother. And she believes and she believes that Mr. Appleby has instilled that in them. There's no way to stop it, I guess is what I'm going to say, but even though you can tell him not to, and it may have happened and it may not have, but that's her belief.
Well, I was listening to something last night. And maybe it was kind of a prologue after something on Netflix about some sort of racially motivated bad things that have happened in history. And there was a little phrase came on, and it was about hate has to be taught. Hate has to be taught. It kept on talking about that, and they were talking about, and I just thought about that for a second. I really never had thought about that phrase, that hate doesn't come, prejudice doesn't come naturally, and hate doesn't come naturally. It has to be taught. And anytime, I don't know, anytime you have these feelings, we do these status quo orders all the time where people aren't to say this, aren't to say that. But we can't be there all the time and police those sort of things. And, I don't know your client, don't know how aggressive she is or what she might say when she's around the children and whatever. So I can't make a decision. But I will tell you that sometime down the road, Mr. Appleby, if something happens to this grandmother and your children have not made peace with her, they're old enough to remember some good things about her, and they'll have problems with that. They'll have problems if they didn't make peace with her. If something happens to all of us, people always say, well, if I was to die, and I'll say, no, it's not if you were to, it's when you're going to. And so, if there's anything that you can do after all this hostility to find it in your heart to soften some and to try to encourage them to contact her, it would be in their benefit. It would be in their benefit, I'm convinced. As far as the medical records are concerned, medical records are private sort of things. I don't know how long you keep the friend of the court involved in anything, but I would say that maybe for a period of 3 years, I'd like periodically for the friend of the court to have access to medical records that the friend of the court will keep confidential, and not share them. And if there's anything that arises to the level of injury or that sort of thing, then the friend of the court will put this back on the docket and bring it back in. That should give your client some assurance that there aren't things going on, and yet protect the privacy of the children.
Reasonable way to approach
involved. Okay. And so I will be very, I'll be very encouraged if you try to get those kids to start contacting this lady. And I'd also be encouraged that when they do, that you just to be appreciative when they call and let the past be the past too. It's hard to do, especially when you've lost your child and you're trying to keep some connection with your grandchildren. I know nothing could be more difficult than that. I don't think, everybody needs to keep that in consideration. Could you draft something?
Yes.
Thank you very much.
I will.
Thank you.
Thank you, Jeff, for me. I'll home.
Matea Lee Watson versus Barry Shane Roach. Yeah, you filed a there's a response filed for ex parte motion for custody and suspension of visitation and to set aside. So I guess let me hear you first, Mr. Mary.
Judge, I didn't get this until the Tuesday after Labor Day weekend, and the very time that I got it, I forwarded it to my client who had just gotten out of jail from the DBO hearing you all had the week before.
Yeah.
And I asked him how to respond to this, and before I could get the response, you entered the emergency order that was attached to the ex parte motion. So by the time he could retain me, obviously his time sharing had been suspended for a couple of weeks. I got to looking through this, and Judge, the affidavit was based on nothing but hearsay statements that apparently the petitioner had with her, I think, 10-year-old daughter. There wasn't any direct statements that my client is supposed to have said to her that led for the basis for having his time sharing suspended. Now, these parties were never married, so obviously KRS Chapter 403 really isn't applicable. But if the court was going to look at how you modify the time sharing that was set up in the mediation order that was just entered in February of this year, and then modified in April of this year, you have to have certain statutory factors, none of which were identified in the motion or identified in the affidavit. There's nothing that's any kind of emergency situation that leads to some kind of physical injury to either of these children. There's nothing that's psychological or mental. There hasn't been.
So says you. Now,
That's
you weren't here at the EPO hearing, and I'm kind of in a family court situation here where I have I heard the evidence in the EPO, DVO, EPO, and now I get this motion here. And I might have been tainted somewhat about what I'd heard in that other motion that wasn't in the affidavit. But I will tell you this, I don't know, I'm sorry you didn't get this in more timely manner. It's not my fault that you didn't. I guess it's a holiday weekend or something. I don't know what's good. It seems like these things are. But Mr. Roach, the things that were, it wasn't hearsay about these emails and or texts and that sort of thing, things that he had been saying to these children that that wasn't hearsay. Now I'm ready to have a full-blown hearing on this thing. And if you think that there are technical problems, the way this is entered, it should be dismissed facially. I'll hear that too. You know, but you know, I'm very concerned with Mr. Roach. You know, about his actions toward these children. Very concerned about from what I've heard at these hearings.
Judge, I mean, if you want to set for an evidence you're hearing, we're prepared to go with it today. I mean,
I'm prepared to hear it today.
Yeah,
I'm prepared to hear it today because I surely don't want to interfere with his visitation. But some of these things that he said to these children, you know, about not sticking with me and all. I mean, it's unbelievable to me. Some of it is.
well, Judge, I mean, there is, you know, the thing about a chain of text messages is you're not getting the full context of what went on before and why he got to where he said something. But a text message that he sends on a phone that he's paying for his daughter and shows up attached to an affidavit filed by the mother, that's hearsay. I mean, the only way that could come in is through him being on cross-examination, being asked, did he say this and why?
Well, that's the reason we're here today and having a hearing, okay? But I will tell you that as long as I sit on this bench, if I get copies of texts that someone has received and they seem to be, you know, in order that someone received it on their phone, if I have to take an immediate action, and it interferes with someone's visitation for a short period of time in order to protect children from psychological damage, then I'm going to enter those, and then we'll have hearings and I'll withdraw. I mean, my first thing is to protect the children from what I believe would be severe psychological damage. And that's what I did. I don't regret it. Now, I hope I'm wrong. I hope those messages weren't sent. I hope he didn't do it, but I don't know. That's the reason we're having the hearing today.
Judge, they weren't sent to the petitioner. If they're supposed to have allegedly been sent to his daughter.
So I should ignore them then.
I didn't say that.
Well, okay, we'll have a hearing. You'll have your opportunity to be heard. Okay, thank you. We'll go at the end of the document. Mark Swanicky versus Michael Boyd.
Good afternoon, Judge.
Hello, how are you?
Fine. Hope you're the same. Last time, Your Honor's case was before the court, I'd filed pretrial compliance and instructions, and Mr. Boyd's attorney had not. Now she has also. I had a motion for a trial date, so I take it that's what we're here for today.
Okay. You want a jury trial, of course.
Well, we didn't express a preference, but either one would work.
I think people, I know a lot of people do bench trials, but when things are all said and done, I think people feel a little bit better about it if they have a jury trial. Even if you don't request one, I'm going to deny a bench trial and set you a jury trial, you know.
Okay.
Especially when people are from the area and they think, you know, somebody might know this person. You think you try it in 2 days?
I would think so, yes.
How much in advance do you need?
Do you have a preference? I would say 60 days to make sure we get all the subpoenas out.
I think I meant we've got a couple of surveyors, probably. One's been deposed, one has not, so we need to.
So you don't have all the depositions finished then? Supposed to have all the you're supposed to have all the depositions finished before we set the trial.
Correct. I think the deposition that I was on has been taken. About Mr. Wells.
Well, I've taken all that I needed to take as far as depositions. I think I'm the only one that did.
Do you have other depositions?
Not to my knowledge, Your Honor.
Well,
I was not
you're
in
the
the
only
case.
one that has any knowledge.
I was in the case when, well, I was not in the case when we.
Mr. Boyd's not taking any. That's my.
My presumption, Your Honor, would be that we would call those witnesses.
Okay, that's fine too. What about the 19th and 20th of December?
I'm okay. Are you okay?
Yeah, I think I can do that. Not sure jurors will be thrilled about being called at that time of year, but.
Okay, well, I don't. I'm tell you the truth, I'm not too thrilled about it either.
I don't do a lot of cooking and shopping, but others do, I know.
I'm okay with that trial date. I'm okay with others if there's others you wish.
You know, what's after the first year, would you prefer January?
Right now, Your Honor, I have a trial at the end of January and I have a trial kind of the third week of February.
So December works better for you?
Well, early January.
Well, let's look at earlier January then. Hold on a
Early
second.
January.
How about the 29th and 30th of November?
Let's say you. You prefer that to December?
I do. Yeah, I think the point about the holidays is probably correct, you know.
It'll be after Thanksgiving and before Christmas. I've got a major deposition on the 28th, but that shouldn't be a problem. Yeah, and will there be any other pretrial compliances you need before those dates?
I think it's been finished, or I wouldn't be sitting. Neither one of you have any objections to pretrial compliance, Steve? You both given instructions?
Yes.
We've 10 instructions that say just, because the jury issue is not clear to me, but
Well, I mean, that's one of the things that the pretrial compliance has to say. I haven't seen your pretrial compliance, but
we have filed it. You know.
Well, did you electronically file it? Well, see, that sometimes I don't get those.
Yeah, but she has complied.
Yeah, or did she give instructions?
Yes, Your Honor. She did.
So those instructions you consider to be the jury issues, right?
Your Honor, I did, it just, I noted in there that no one had requested a jury trial. I would understand that the court could have an advisory jury regardless.
Well, I'm just gonna have a flat out jury trial. So,
Okay.
let me make sure I got that second day, 29th and 30th, right? Okay. Okay, well, thank you all very much.
Thank you, Judge.
Thank you, Judge.
Have a great day. Southern Kentucky Tax Partners versus Perry Owens. Hello, how you doing?
Your Honor, Southern Kentucky Tax has filed a motion for judgment in order to sell.
Is this a tax lien case?
It is, yes, Your Honor.
Mr. Bailiff, you want to you got a judgment ready?
I filed it electronically, Your Honor.
Okay, okay. I'll sign it today.
Thank you, Judge.
Yeah. Brandon, Thompson versus James Fisher and others.
Your Honor, that's my motion for summary judgment on the pleadings. It's a foreclosure. We just got in the case and had a guardian ad litem appointed for an incarcerated defendant. Mr. Poindexter has filed his report. It's a substantial piece of property that I'm trying to wear a belt and suspenders on. So what I'd like to do is update my title opinion and send you a judgment order of sale.
Is this indivisibility of property?
No, it's foreclosure.
But for whom?
For the Thompson Trusts.
Yeah, I just couldn't figure out what Thompson Trust. was.
They're furners, as they say. They own
I looked at,
a piece up around Dutch Creek somewhere.
it's at the head of Dutch Creek.
Apparently so.
Well, that'll always be good for some surveying treats at the head of Dutch Creek.
Of course. I haven't looked to see if Mr. Poindexter's report's in the file. He filed it electronically. I presume it is.
See,
We'll be sure it's in there.
well, just go ahead and so you're wanting to supplement.
I just want to be sure that we are still good on our title. And then
Okay, well, I'll pass over it and then you don't have to, you don't have to redocket it.
Right.
Just forward.
Send it to you next week. Thank you.
Okay. Mary C. Moore versus Emily Moore.
That's fine. We won't get a hearing on that when we reach that rate.
Okay,
Document, I can check it.
okay. Michael Kerr versus James Bradley Kerr.
It's
Go ahead. Hello. Mr. Kerr, you have an attorney?
Judge, of course, this was set today for a hearing on our motion, ex parte motion for custody. And the court granted it based on the affidavit and the copies of the EPO that we attached. And then I also have asked the clerk's office, and I've got a copy here too, to bring you a copy of the DBO that was entered yesterday. And I have that complaining witness available by Zoom.
Hey, did the district court, I haven't seen that order. Did the district court do anything about custody?
Well, of course, that EPO did not involve Mr. Kerr and any children. But the court did go ahead and enter a domestic violence order against Mr. Kerr as he failed to show up yesterday for court. And then the petitioner was present and gave testimony under oath.
Why weren't you at court yesterday, Mr. Kerr? You weren't served?
You can play it up or something.
You weren't served?
I was told that.
Who told you?
Well, whenever I had my hearing for the EPO, I was told to be in court the 26th.
Who told you that?
Oh, it was at my last hearing.
Oh, do you have any papers that say that?
Not with me, no.
That's good. Need anything you want to bring up in court, you need to have with you.
I wasn't aware I missed anything.
Now you know you did. You need to get counsel. You need.
I've called several lawyers.
Well,
They will not return my call.
Well, and then you need to go to somebody's office or something. You need a lawyer. Because there fixing to be already been some decisions made that will affect you greatly. There was a DVO entered. That, you know, that has a long-term effect on you as far as your ability to have firearms and do other things. I mean, it's not good. And if you actually can prove that there was a hearing that you had a misnotice or weren't noticed, then you need to bring it back up. It's some juncture. As far as today, were you served with papers in this case here about the emergency custody order?
Yes.
Okay.
Captain.
And you still don't have a lawyer. I'm gonna, rather than have an evidentiary hearing today, I'm gonna leave this order in place for till the next rule day to give you an opportunity to get an attorney to look over all of your situations with this. And if you want to, I would suggest, not my business, but I'm suggesting anyway, that they look at the DVO aspect of it too. See if you weren't given proper notice of that or whatever, you might be able to have that reconsidered. I don't know what the deal is, but there are some serious allegations made in the affidavits in the DVO. Okay. So I want you, so there's no mistake about it. The next time we're here is on October the 27th. I would suggest that you get an attorney that contacts her attorney and they start in some conversations to see what you might be able to accomplish. But I'll leave this order in place until then. Okay. Okay. Thank you very
And
much.
just for the record, I think they have been making arrangements for telephonic or video visitations with him and children.
All right. Will you be careful what you say to them? Okay. Okay. Thank you very much. Now, this is the next case on here is Bobby Severe and others versus Wanda Sue Huff. What do we have here?
Your Honor, I filed a motion to dismiss on behalf of Mrs. Huff. The basis of that motion to dismiss is there was a 2018 litigation regarding the same parcel of real estate.
Well, I disqualified myself from that case before because there was a deed that was in dispute that was done by my office. My secretary Susie did the deed. She's deceased now. May she rest in peace. So is this about that same piece of property?
It's about the same piece of property, Your Honor.
I don't, what do you have to say about that?
Judge, we've just filed an adverse possession complaint about that piece of property. She's attempted to kick it out with claim preclusion and issue preclusion. Our position is those elements don't meet in the case. It's obviously two different fact patterns.
Well, I think you might have some merit to that, but I'm not going to rule on it because I was involved, my office was involved in the deed. And I have no recollection. People say, well, don't you remember when you did that deed for so-and-so? And or when you handled mama's estate or did something like that. And
It was only
actually,
1985.
well, I know, but I don't remember when it was.
Your Honor, I anticipated that might be your decision.
2005, I don't remember. I don't remember, but I know there's been a long running conflict. So I'll submit and get a special judge appointed.
That'll be fine.
That's fine, Your
As
Honor.
soon as possible, okay?
Judge, that's all I may be.
Oh, yeah,
Thank you.
absolutely.
I guess, Your Honor, I would say Judge Lay, and I don't even know if he's still on the bench or not. He was the judge out of London.
He is still on the bench. I know.
Well, he is the chief circuit judge. And he's the one that makes assignments when I recuse.
Okay.
When he recuses, I make the assignment because I'm the deputy chief circuit.
Okay.
So that's where this will go to him, and he'll either take it himself or get some eminently qualified judge east of here because there are no judges west of here.
Thank you, Your Honor.
Thank y'all very much. Yeah. Kerry Harris versus Stephen Harris.
Move around a lot. I don't know what to do.
Hello, how are y'all today?
Judge, we've already talked to the DRC's office about getting a date for the hearing, so the only issue before the court now is just asking for court ordered mediation prior to a hearing.
What would be the purpose of that?
To see if we could settle it.
Well, you don't need to have a court order to do that. What are the issues? Are they property issues?
Yes.
Just one minor child?
Yeah, we've
I
reached,
know, I would just say, I know these people very well. As a matter of fact, I don't know whether both of them have been in my home. I believe they've been on my property. And of course, Mr. Harris's mother was a caretaker for my mom and dad when in their declining years, and was also worked at my house for a long time. And I know, and I have known Miss Harris because that relationship of all of those families. I will not recuse myself because of that, but I just remind people, I don't really like judges recusing themselves. I mean, if every case was an easy case, then you got off all the hard ones, but y'all might want to consider that. Both of you might want to consider on whether you want me to sit on the case, not because you necessarily would insult me, because you might always wonder whether or not my decision was predicated on some knowledge that I might have of the parties and everything. But I think very highly of both of them right now. I hope I don't hear anything that make me feel differently about either of them. But I don't know whether court order mediation. Do you think you need court order mediation to sit down and talk about this case?
Judge, the main issue is the marital residence, and I think mediation could be beneficial. We've not been able.
What
to
is the issue about the marital residence?
both parties want to keep the
Yes.
residence, Judge.
Okay. Well,
And we've done several offers back and forth, and we seem to,
where is the marital residence?
It is located on GDO Road,
Judio Road.
my neck of the woods.
Yeah.
my former stone.
And there may be an issue, I think, with a division of retirements.
Yes. The things I usually find the most difficult, which are the custody and visitation, we've reached an agreement on that issue. It's just these are the two bigger property aspects.
Okay. Well,
And we'll continue to try to negotiate a settlement, but we would just like something in place saying that we need mediation if we can't get that settled, because I do think if we had a mediator,
you all have one you want to agree to?
I mean, I'm fine using Judge George if Miss Perigin is.
Ms. Capps has threw that out. I think that we can be agreeable to Mr. George.
Judge George is a bright fellow.
He does it by Zoom now, so that saves the clients on traveling expenses and different things.
Yeah. Okay. Well, do an order with Judge George and then proceed with it. I guess with get on domestic situation, domestic relation commission. All right.
All right. Thank you, Judge.
Okay, thank you.
I'll get that to you.
Wenzel versus Wenzel. Wenzel versus Wenzel. Yeah, Mr. Wenzel.
Your Honor. Yes, Your
You all
Honor.
right? Okay, this is self-help.
Yes.
Okay, what are the issues? Are there any issues as far as the property or anything concerned?
No,
Y'all have any property?
we do, but we agreed to.
Can you hear her, Mr. Wenzel?
Yes, Your Honor.
Okay, do you have any objection to divorce being entered and the proposed decree being signed, sir?
The divorce, no, the custody part, there's a little bit I have with, but I don't know.
Okay, well, tell me, is your order going to include custody issues?
Yes, sir.
Okay, what would you want?
So I want sole custody, and I want sole custody because I had got his response and he wanted me.
Okay, well, you need to raise your
Oh,
right.
yes, sir.
Swear the testimony you're about to give is the truth, the whole truth, nothing but the truth.
Yes.
You can lower your mask if you'd like, so I can understand what you're saying. Go ahead.
Yes, sir. I'm requesting sole custody and he wants joint custody. I would like sole custody, because he's out of state. And in his response.
What's he doing out of state? Why did he leave here?
We had gotten to an argument. The next day he had packed his things and left, his job, everything.
So I just feel like he's, not really responsible. And, you know, when he left state and stuff in his response, you know, he responded back that, you know, he wants joint custody. And I don't want to do joint custody because you know, he also said because he wants me, I need his consent for medical purposes and things like that for our child. But you know, I'm more than willing to, you know, keep him informed and, you know, tell him things. I'm never going to keep anything from him.
Okay, you have any questions you'd like to ask her, sir?
I don't have any questions. I just have a couple statements.
Well, you'll get your opportunity to do that in a minute. I'm just asking you right now. You got no questions. Do you have any other witnesses? That you like?
Actually, I have a couple, there's a couple family members who actually had reached out to me.
Are they here?
No, but they had.
Well, they can't testify.
They can't, they sent me documentation
About what, documentation of what?
about the safety of my daughter,
About what?
about the safety of my daughter,
Well, you
sir.
can tell me what you believe.
Okay. Well, I think that I don't think that she would be in danger around, you know, my Cole, the father, but around the grandmother, I do. I think she would cause a lot of psychological harm to her. And I say that because multiple family members of him, and I have, you know, emails, text messages, everything.
Okay, well, that you got.
Yes, sir.
Some hearsay, sir.
Yes.
Sir, you raise your right hand. You swear the testimony you're about to give us the truth, the whole truth, nothing but the truth.
Yes, I do.
Or that, and you make you, I'm gonna let, I ought to make you ask yourself questions, but I'm just gonna let you make a statement and give her an opportunity to ask you any questions. What is your statement about the custody of the children?
All I want is joint legal custody. So I know that, like, I understand if it's an emergency, death, limb, or eyesight, that's just out the window. It's a yes or no with her. But just for like major.
Okay, you need to speak up a little bit and make whole sentences and not presume that I know anything, okay, about this. Start again.
Yes. All I'm asking for is joint legal custody so that if it ain't like death or life, that I'm aware, if it's like a major procedure, that I'm aware, and that when I like, there was times where I asked her, because I finally was able to get insurance. Well, I needed my daughter's social and birth certificate mailed up here, like a copy of it, so I could put it with my medical insurance that covers everything. And I was told that she already had insurance. And then come to find out a month later, I had a $3,000 or $22,000 to $3,000 medical bill from my prior insurance. So when I asked Miss Sarah Wenzel why I'm getting this bill, she was under the assumption that she was still under the insurance I previously had, when I was told that she was under the insurance that she is where she's working and under Medicaid. So I was trying to do the right thing and make sure she had insurance, but then I'm turning around getting bills. And I'm just trying to, like, that's the main reason, like, my biggest things are joint custody. So I have say in joint legal custody. I have say into certain procedures, and there's my visitation rights during the summer and like alternative holidays, major holidays. And the reason why I left, Your Honor, was because it was a constant getting kicked out of the house, living in my Jeep, asking my family for money to live in hotels because I couldn't afford it. And I tried to find, I was out of the house for a week, or about a week, until I made the decision to move back up to where I'm at, due to the fact that I could, with the pay I was getting, the hourly rate I was getting, I could not pay for a place to live. So
okay, what I'm going to do is I think this is going to be a little involved here. So I'm going to refer you to the Domestic Relations Commissioner to take proof and make recommendations on a thing. And if either one of you want to get a lawyer before you go to the Domestic Relations Commissioner, just someone who hears contested matters for me and makes recommendations. So it would appear to me that both of you have fairly strong feelings about where you are and why, why you left and that sort of thing. So we probably need some testimony about that. Now, I would suggest that you don't necessarily have to have the joint legal custody to accomplish some of the things that you want to do, sir, but I'm not in a situation to give you legal advice. So I would suggest that you might try to find a local attorney that would go over the parameters of what you can accomplish in the least burdensome sort of way. You understand what I'm saying?
Yes, sir.
Okay, so I'm gonna go ahead and refer this to the commissioner, and you can y'all have the commissioner's phone number up here. Okay, you have a pencil and paper there, sir?
Yes, sir.
Just call out the commissioner's number. 606-387-8112, and that's the commissioner's, Commissioner Sohn, S-O-H-M, Sohn. And if y'all will call over there and schedule a time where, and I don't know whether he does things by Zoom or whether you have to be present or not, but if you will go ahead and have hearings on this, and he'll make recommendations. I suggest both of you think about getting a lawyer, because this is not a simple uncontested divorce. Okay, thank y'all very much, and I will bring this thing on review. Is there any agreement as far as temporary visitation or anything?
No, but I would, she's 1 year old. And I would be okay with him coming down to see her, but Minnesota and where he's at is like a 20-something hour drive. And I just feel like that's too hard on my infant. So I would be okay with him coming down here and seeing her. But as far as traveling all the way up there with
Well,
her,
I want to enter an order that we'll draft that will allow reasonable visitation with him, with the child, if y'all can get along well enough to do it, but that the child shall not be removed from the state of Kentucky.
yes.
Okay. Then that's just for a month or so, or I'm going to keep it in place until we have a commissioner's recommendations. Okay.
Okay.
So y'all work it out with each other as far as now, is there somewhere down here, sir, that you would feel comfortable visiting with the baby except your wife's home?
No.
Okay, well, then y'all have to get along well enough. I would suggest that y'all have any mutual friends here that could be present when the visitation took place.
No, but
we
as
can
long
meet-
as, Mr. Wenzel just,
Well, I know if y'all could do that, we wouldn't be here.
Yeah,
I'm just anticipating.
well,
You have somebody you want to suggest, sir?
I mean, if
Neighbor?
you want to meet in front of the courthouse and I don't, if you don't want me there, I still
She
have,
didn't say she didn't want you anywhere. I'm just anticipating that y'all might have issues. And I'm just suggesting it'd be good to have for both of you to have a witness when the visitation comes place. So both of you be assured that what do you suggest, ma'am?
I would be willing to do that.
Do what?
To visit with him, or not with him, but to meet him, as long as there's like maybe a sheriff or in front of the
Well, I'm not
courthouse.
going to make the sheriff's department work full time. What I'm telling you is if you have no friends here.
Oh, I
Who
do.
do you have here?
I have my coworkers and things.
Who
like
are
that.
your coworkers? Where they work?
At Cumberland Valley Manor.
Okay, who would one of those be?
There's Kathy, I have a bunch of them. I'm sorry, but
Well,
I can,
is there somebody, what about Natalie Kraft? Do you
yeah,
know her?
Natalie, yeah.
Why don't you ask Natalie Kraft if she would make herself available? She's the head of nursing or whatever down there. And she's a responsible person that I know, sir, to make sure things go smoothly. She doesn't have to be interfering with it, but see if she would agree just to be present.
Okay.
Y'all pick someplace pleasant where you can do your visitation at the state park or somewhere, at the lodge down there where you can have some private time with the baby and that sort of thing. And y'all can be together there, but it'd be good to have a witness. Okay.
Okay.
I'll try to draw some kind of order up to that effect and send it to you. And maybe y'all can get together, and I'd suggest both of you get an attorney. Okay.
Okay.
Thank you very much.
Thank you.
Garner versus Renault.
Judge, this is my motion to get some type of temporary custody order in place until we could have a hearing. And Mr. Hampton contacted me yesterday to inform me that he has COVID. And he sent a text message that I've showed to the guardian ad litem just a few moments ago that we can we'll submit an agreed temporary order on joint custody to the court.
Okay. Well, I like agreed temporary orders. So, are there any, is there marriage involved here?
Well, this situation is we filed a de facto custody petition because my client is actually the biological paternal aunt of the minor child involved.
So this was it's biological. Has there been a finding of paternity in the case, or is it just acknowledged?
I think it's just acknowledged from my understanding, Judge. And the couple, the mother and the father are not married. They just have this child together.
Where's the father?
The father's in Bowling Green with the mother. And that's my client's brother. But they brought this child to her and she's been caring for him for well over a year now.
And the child's still here?
Yes.
And you've interviewed everybody?
I have only had a chance to interview Ms. Garner. I was not notified by the father's attorney that there would be a hearing today. I've not had a chance to get with the father.
You've had the child for how long?
I'm going on 15 months,
Yeah.
full time.
So I'll submit that order to the court, Judge.
Yeah, you want to get in front, you want to go ahead and try to get in front of the commissioner real quick?
Yes.
Do the thing real quick and get in front of the commissioner. Okay, thank you very much.
Thank you.
Now, if I skipped over anything other than in case we're going to have a hearing.
Yes, this one right here.
Your Honor, Mr. Garman and I have a matter that at some point in time this afternoon, it's not on the docket, it's a Clinton County.
You're out of luck then.
Well, it's just SOL, what can I say? But we have to.
Let me have one, I got one other thing that is on the docket. And it's Bricker versus Bricker. I guess that's Ms. Capps that's involved in that.
Ms. Katz and I, Your Honor, I think we issued DRC dates on that.
Okay.
While we was together.
Okay, that'll be fine. Now, what do you and Mr. Garman have?
Well,
Mr. Garman, do you want to get involved in the discussion or you want Mr. Garman?
sure.
Yeah, get behind the podium.
It's a little, it'd be better if we retired the chambers for about 3 minutes. We're not no secrets, but it's just easier to explain for flow.
Well, let me go off the record here and stay on. Is it something that you want, both of you want to communicate off the record?
Yes.
I can't hear the audio. I can't hear. I can't hear you. I know I can't hear you. I could hear you until just now. Hold on. Let me try again. Judge, I can't hear you either.
I can hear you now.
You can hear me, but neither one of us can hear the judge.
Oh. I could hear him until we went until that last little bit.
Yeah, me too.
Can you hear me now?
Yes, sir. Yes, Your Honor.
Megan, can you?
Yes.
Okay. Dean versus Sparks. Was there anyone outside? Did the bailiff find anyone outside that was here on it? Dean versus Sparks.
Your Honor, we are requesting an order to show cause for 525 to be paid by the 16th.
Hold on just a second. Hold on. I don't have your picture. You got
Oh,
somebody?
I'm sorry.
Do what?
There's one bill that's here for the Adair
Have whoever's for the Adair County Child Support come back in here real quick. There's someone that's shown up here.
Okay. Let me get on. I'm sorry, Judge. I'm having all kinds of trouble. I don't know what the problem is.
I don't see your picture now.
I'm trying to get on there. I don't know what my computer's doing. Hold on one second. Let me get somebody in here to help me. Gina, I'm having trouble. If you could come in here, please. I don't know what it's, you can't see me.
What's your name, sir? Rich Hart. Okay, well, we're trying to get the computer set up. Wait just a second.
Yes, sir.
Pull that screen over there. Pull that screen over. Pointed toward him.
It says it's not responding. I've been on since for a while, but it's not letting me, I can't do anything.
Well, I can hear you. I can hear you and you're on the record.
I'm sorry, Your Honor. I don't know what.
Okay, I can hear you. Let's go on. Dean versus Sparks. Evidently, Mr. Sparks is present here.
Okay, Your Honor, we are asking for an order to show cause for 525 to be paid by November the 16th. And if not, for him to be in court on the 17th. Mr. Sparks was in court last month, and we received, I think they did a garnishment, the state did a garnishment, and we received a partial payment from him. And we're just wanting to make sure that that continues.
What do you have to say, sir?
I've talked to Dennis Loy over the court, being the jurisdictional problem. He told me to hand you these papers, and it's being garnished from my paycheck. And I have copies of that. I haven't seen my daughter in 4 years.
You need to speak up.
I hadn't seen my daughter in 4 years. He told me to file.
That has nothing to do with the child support.
Right. Well, I have paper on that right there too. It's being taken out of my paycheck.
Okay. He says he's got these garnishment papers. You acknowledged you garnished money?
I acknowledge that the state garnished money. We didn't know, he did not tell us he was working anywhere, so we didn't know that. But the state, yes, the state of Kentucky, Commonwealth of Kentucky garnished wages. Yes, Your Honor.
Okay. Yeah, I've got a document in front of me here that says they're garnished.
Yes, we've gotten one payment, I think it said, they said, the office said.
I don't see the amount. I'm not familiar with these.
It says 60, it's 240 something a month. $60 for taking out last week, $6 a week.
Do you have those in front of you there?
Just 1 second. Let me get Linda. She did not. I need the file.
May I say something, Your Honor?
Wait a second.
Okay.
It says $60.58 per pay period.
Oh, Judge, I'm sorry. I have the file. I apologize. Okay, I've got the order and it says $262.50 is what's being withheld, and they would take $60.58 if he's paid weekly.
That's right. And 121.15 bi-weekly.
Yes, sir.
Yeah.
Yeah, that
Okay.
was
If he
generated.
remains employed there, will that be sufficient for you?
That's the Summit, it's someplace out of Michigan, that we sent a wage garnishment. Looks like the wage garnishment was sent September the 12th.
So if he remains employed at Summit Polymers, and can they continue to do this income withholding for support, then that'll be sufficient for you. Is that what you're telling me?
Yes, sir.
Okay, I'm gonna let this suffice. Are you gonna stay employed at this place?
Yes, sir.
Okay, well, if you leave employment, there's gonna be an order today that you shall immediately notify the the county attorney's office in Adair County that you're no longer employed there. Will that be all right, Ms. Hutchinson?
Yeah, that'd be great, Judge.
And then you'll need to tell her where you are employed.
Yes, sir.
Okay, I'm gonna let you take this back since she's already got a copy of it. Okay, thank you very much. Okay. Okay, now, I'll go ahead and do you may go.
Okay, thanks, sir.
You got the next case also. Wait a second, sir. Richard Sparks versus Megan Ashley Swartz. You're on the other end of that, right?
Yes, sir.
What you got on that, Ms. Hutchinson?
She signed an agreed order, to have $492.50 paid by the 16th. And if not, then she's to appear in Cumberland Circuit Court on November the 17th at 1:30.
Okay, okay. Thank you very much. Do you have any other cases beside that,
No,
Ms. Hutchinson?
no, sir, Your Honor.
Thank you for your patience.
Thank you. Bye-bye.
November, what he said. November 17th is correct. Okay, you can go.
Thank you, sir.
Okay. Okay, now let's do this confidential matter. What do you have?
Judge, we're ready to proceed with the adoption.
Okay, we're here in civil action 18 CI 0007. The court has previously signed an ex parte order for emergency custody and suspension of visitation and motion to set aside ex parte order. Response has been filed. Now, what I'm gonna do here as we start this thing, I want to let you present your evidence as to why you think there should be some permanency in this situation, with the understanding that we're going to dissolve this emergency custody order at the end of this hearing. So the issue of whether it was adequate or not can be taken up in some other venue or somewhere. I'm going to decide based upon the evidence I hear today. Now, before we do that, Mr. Meredith, what you're talking about the different statutes that we ought to be dealing with. What statute do you think that we should use a criteria I should determine on making this decision? What statute? Let's go over.
It was, the custody was set under KRS 405.021, because these parties were never married. And then also KRS 405.028, unless my client's been convicted of a felony offense, which he hasn't, his custody right should not be set aside under KRS 405.021.
Judge, he's still on grandparent visitation.
Y'all need to come up here where I can hear you. And you can take your mask off. You can stand over the side here. And you just come up behind the podium. And what are you saying?
Well,
you can take your mask off.
Thank you, Judge. Let's go back to my notes, so make sure I'm not misquoting anything. Since these parties were not married, KRS 405.020 would indicate to the court that it should consider a joint custody relationship, which the court already has, because the original 2018 order was a joint custody relationship. Even
talking about what has happened since.
Yes, I understand. Well, what's happened since then? The only thing that I have seen, Judge, is under KRS 405.028, custody, visitation, or inheritance rights can only be taken away if somebody has been convicted of a felony. Now, if the judge wants to.
Wait a second. So you're saying no matter what this man says to the children, about the children, whatever he does, they can't bring in and get relief unless he's convicted of a felony?
I haven't seen a crossover statute between KRS 405.020 and KRS 403.340. But let's assume that there is a crossover statute. KRS 403.340 would provide you the basis in which to take away joint custody rights if only there's a serious endangerment to the physical, mental, or emotional health of a child.
I agree with that.
But I haven't seen any case law that's interpreted a crossover between parties who are not married, who have a joint custody relationship under KRS 405.020.
I'm going to apply that by analogy, if nothing else, but you go ahead and respond to that one issue. There's bound to be some relief when someone, are you saying under your interpretation law, when someone endangers the physical, psychological, mental health, there's no relief under the law? Is that what you're saying?
I didn't say there's no relief, Judge. I just said I didn't find any crossover statute.
Well, so there would be no relief. What would you think the relief is?
At the best, you're going to have to then follow KRS 403.340. Because even under 405.020, if the court was setting
340 would, what kind of findings are you saying would have to be found under?
You have to find a serious endangerment to physical.
And I've already agreed to that. I've already agreed that would be the standard. That's the standard I'm going to apply.
That's the standard if the parties were married. But I'm going to assume, since there's a crossover statute under 405.020, for the court to consider factors for 403-270, I'm assuming that the legislature
and talks about the rights of a parent that's convicted of a sex offense against a child. So I don't know how those are applicable. When you go to KRS 403-340, it references that the court uses 403-270, the best interest statement of the child in modifying the custody decree. So I think those are the appropriate statutes that the court considers, not these others that he's citing
What
to.
do you say?
Well, you had to have initially found custody under KRS 405-020 because these parties were never married. So otherwise 403 would never have applied.
Judge, that's not the applicable statute. 403-270 and 403-340 deal with custody of children, whether parties are married or whether they're not.
What is 405.020 do?
Talks about the physically and mentally disabled children as far as a de facto custodian, and that the parents have the right to joint custody, nature and education of their children under 18. But if a parent dies, what the court is to do in that. Because 405.020 subsection 2 deals with an adult child that is disabled. 405.020 subsection 3 deals with de facto custodianship. And then 405.020 subsection 4 deals with, again, if a parent is deceased. And then subsection 1 just talks that they have the right to joint custody and nature and education of the children under 18. And then if either parent dies, what happens? So again, I don't think that that's relevant necessarily for the determination of custody factors in this situation.
I didn't cite subsection 2 to 020.
Well, I just read off every subsection of the statute.
Certainly did cite 1. Because that's where you're directed to go if you have paternity issues starting off with on custody. And again, I just didn't see a cross.
I don't think we have a paternity issue. I mean, unless he's now saying he's not the father of the child.
That's the statute that you start off with, and we've already used that statute to set a joint custody relationship. So the only thing I brought up to the court's attention was.
You use 405.0.
Subsection.
We did not use that. 403.340 talks about when we're modifying a custody decree.
I don't have 405.020 in front of me. We're going to rectify that. 0.020. You can keep that. I'll get it here. Okay, do you have 405.020 in front of you?
Yes.
Ms. Capps, it
Yes.
says, the father and mother shall have the joint custody, nurture, and education of their children who are under the age of 18. Now, that's just a statement there. Right?
Yes, Judge, but that's not the end of subsection 1.
We're just going along.
Yes.
Okay. If either of the parents dies, the survivor, if suited to trust, shall have the custody, nature, education of the children under the age of 18. The father shall be primarily liable for the nurture and education of his children who are under the age of 18, and for any unmarried child under 18, and the child is, well, I mean, that's bound to be an antiquated statute there because it talks about the father being. So. I mean, that's a general statement that says that joint custody that mothers and fathers shall have joint custody. That's what that says. Correct?
That's correct.
Well, okay. Now, so you're saying that modification comes under what statute?
403, 340.
Okay.
And then it also references the factors in 403, 270, Judge. So I think the court needs both of those.
And D says whether the child's present environment endangers seriously his physical, mental, moral, or emotional health. Whether or not the harm is likely to be caused by a change of environment is outweighed by the advantages to him. Correct?
That's correct, Judge.
Okay, well, I don't think we're that far apart on what we believe. Then go ahead and put testimony on.
Judge, do you want me to bring her to the podium or?
I like to go to the stand here.
Okay. Call Matea Watson.